Protocol 19 in the audio video clear idea?
Madam, clear ಇದೆ.
Thank you.
ಸರ್ ವಾಯ್ಸ್ ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್? ಹಲೋ ಹಲೋ
ಕೇಳಿಸ್ತಿದೆ.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
Honorable Court may be unmuted now.
Pardon? No, put it, Nale. Yes. All matters tomorrow, Mr. Pass it on. It will come tomorrow, yes. Learned counsel for the petition has filed a memo that the petition has become infructuous. Memo is placed on record and the petition is dismissed as infructuous. Petition is dead. Petition number 3. Please argue the matter. If you file necessary application before the civil court, this is only an interlocutory application. After 2017 year, the request of the counsel for petition list on. Yes, madam. Put it. Number 47. Learned counsel for the petition has filed a memo that the petition has become infructuous. Memo is placed on record. Petition is dismissed as infructuous. Yes. Number 33. Is what do you want? This is an injunction order. How much time you want? Yes, to. At the request of the counsel for petition this town. When do you want it? Today it is 12th, 19th, 20th, 26th, 26th September. Yes. The request of the petitioner, learned counsel for the petition is on 27th.
Serial number 31, my lord.
Lawyers on the
Serial number
receipt.
30.
I've been repeatedly telling you should wait for your turn. I'll come back to you. Don't.
Sorry.
2016 no time. ಏನಾಗಿತ್ತು ಯಾರು ಅಲ್ಲ ಅವ್ರು ಮಾಡ್ಬೇಕಲ್ವಾ ಅವ್ರು ಮಾಡ್ಲಿ ಸಿ ಅವ್ರು ಮಾಡ್ಲಿ ಅಕಸ್ಮಾತ್ ಹಂಗೆ ಕೇಸ್ ಗೆದ್ರು ಗೆಲ್ಬೋದಲ್ವಾ $59. What do you want? Sure, wow. Counsel for the petition submits the process, the deficit process fee of which 40 is paid. Office is directed to check, verify, and proceed to issue notice to the respondents 2 and 3. List on 27th. Tomorrow is extended till the next set of hearing. Yes, sir. If he is there in the court, we'll take it up. Idara, is he there in the court? Interim address? That's good. It will come. Yes, lawyers on the VC.
My lord, serial number 31, my lord. Name for the respondent, my lord. Matter is settled, my lord. He file a joint memo in next week, my lord. In Monday or Tuesday, my lord.
Serial number 31.
31.
Guru Raj Kulkarni ಇದೆ.
Yes, non respondent. I inform the petitioner counsel also.
Respondent number 1 submits that the parties have settled the dispute and that they would file a compromise petition. This on 28 September.
Please, oblige.
Anybody else? Very yes. Please give it, madam. Check it. Please give it. The B group ಅಂತ ಕೊಟ್ರೆ seniority ಅಂತ ಬರುತ್ತೆ. So orders ಅಂತ ಬರಿಬೇಕು. ನೋಡಿ ಚೆಕ್ ಮಾಡಿ. Next. Akash Kumar Gowda. Akash Kumar Gowda. Akash Kumar Gowda. There is no representation for the petitioner. List on 7 September.
Serial number 2, I appear for the respondent Kiveta.
Yes.
After working for some time, to go there was understanding because private that undertaking is very important. As something I did for meantime I put in the CH, the respondent, and he responded undertook that other than the above that he did not make any claim on the petition. The state with regard to Poultry was also distributed a claim. This was in December 2020.
Yes.
After 7 months, a suit is filed alleging that a co-existing matter. Page 48 we have identified paragraph 10. Respondent alleges in the suit that he was required to provide an undertaking to the receipt to the defendant, which is the defendant. I will take my administrative papers. I made an application after filing the written statement. I filed an application stating that preconditions will be to the suit. He responded and directed to refund the money. Now, I have relied upon the Supreme Court to identify them and this court. The following where the Supreme Court has had for the contesting litigant who wanted the money and then contested. So judgments of at page number 90 also. I will take into only the relevant paragraph. The first judgment rendered by the Supreme Court in case of related around 91 page 116 candidate. Last paragraph.
Yes.
Page 116. The other feature the rate of 7.5% per annum is harsh and point. And in order to come no longer is we need to get direction. Funds are fine. Only the principal or receiver is modified or
No, was this at an interim stage?
now I have short for the money to be refunded.
No, in this judgment, the judgment in Mansingh, was that against an interim order?
Also, this is an interim order.
Oh, in this case, which is reported in Mansingh versus Maruti Suzuki, was that against an interim order?
Exactly. The second judge.
Hmm.
All 5 cases are typically where workmen allege that they are poor, they are not litigate. Trial court says that no, he is not a workman, he is an officer. Workmen are not simply limited to saying that what are they not. I not come out and all that. That cannot be said to the vice president, sir. Is a very big whatever. My submission is that I don't have any issue with the response with this issue. But let the money be refunded. You cannot have to take that into again, in Mansing's case. Para 18 or 120, 120 para 18. The question that comes for my consideration is whether the interpreter will be ordered directly. These don't have workmen who have workmen deposits for what this is whether for the respondent management who student management all their data which orderly agreed to this within themselves for the service of the first respondent manager. Despite the extremely administrative they find a large authority to run on the position, settlement availability, requiring to not provide over the statutory requirement, is no more significant than no significant violation of the statute. The institute to the also not discussed the related government. Or the economic or income is the only direction to workmen to deposit the amount in the security. It is difficult to find all such improper order. Government cannot contend that the system is okay and do that, but still we take the benefit this is data. Now we have the first deposit the amount in the receiver. Thereafter factors and thereafter that they are both the sides and it is also not even any direction of the direction is only for depositing bonds which workman has received. The relationship is marking by the direction. The direction workman deposit in the report. They are issued by the warrant and cannot become the unjust or improper.
Yes, sir. Yes, sir. Yes, sir. Yes, sir.
My lord,
Mr.
my submission is this, my lord. All the cases cited by the other side relate to disputes between employee and employer who are workmen. In this case, my lord, please turn to his appointment letter. He is appointed as general manager. Page 31.
Yes.
There is a dispute, my lord, whether he was a full-time employee or was he a consultant. Now, my lord, his services, my lord, he was entitled to 3 months notice pay. They didn't give notice pay, summarily they dismissed him. So he has filed a claim for that. And he has received his whatever benefits he had to get, my lord, on the date of retirement or his dismissal, he got it. Now, my lord, these decisions all relate to claims made by workmen in proceeding before industrial court. Now, my lord, please see in the suit here, my claim, my lord, the plain prayer is at page 55.
Yes.
My prayer is for a money decree.
Yes.
Notify the amount due and grant me a decree for 10 lakhs. That is my prayer.
Yes.
Now, in the written statement, which begins at page 56, there is no counterclaim.
Yes.
I don't admit that this any money is due to them. The trial court, my lord, examined it and they filed an application, my lord, under 151. Your lordships will see that application, my lord, at page 70.
Yes.
The prayer is that I must deposit rupees 8 lakhs which I received.
Yes.
And in the affidavit in support of it, they don't say anything. The only point they make is that this 8 lakhs was paid in full and final settlement. Therefore, he is not entitled to anything more. If the defense is upheld, then my suit has to go. But
no, it's not a question of anything more. Now, if you say that this full and final settlement agreement was obtained under duress.
No, I'm not saying that. That's not what I'm saying.
Yes, you have said that in the plain paragraph number 10.
My lord, my case, my lord, is that I was entitled to a notice period, which they did not give me.
No, it's
Therefore,
all right. That is on the merits of the case.
yes, but my lord,
But
can an
some
interim order
money-
like this be granted, my lord, when there is no prayer for counterclaim also?
It's all right. We can direct.
My lord, those decisions, my lord, which have
It's only to create a level playing field.
no level playing field, my lord. Supposing I am not entitled to, my lord, make out my case, my suit will be dismissed. I
Then
am
you-
now, my lord,
Then you make a claim for recovery.
no, my lord, what I'm submitting is,
You
my
cannot
lord,
say, no, first, you cannot say that you receive money under protest, sorry, without any protest.
yes,
And thereafter, after you receive the money, you say that that was obtained under compulsion, force, threat, coercion. And you retain that money and file a suit.
what they give me, my lord, is my statutory dues. My lord, if there is cessation of employment, I can understand if they give a compensation. What they give me is statutory dues, which is anyway payable on cessation of employment. It is not
Where
something.
where is that settlement agreement? Page number?
Annexure D.
Page number 40 and 41.
Annexure D. my lord.
Where does it say it is towards your statutory entitlement?
Page number.
Consultant, you're appointed on consultancy as a consultant.
Yes. From October 20,
If you're a consultant, where's the question of statutory entitlement?
no, my lord, before that, my lord, the consultancy fee, kindly see at page 41, my lord.
Yes.
I have resigned on my last working day company on 30th September. Thereafter, I have engaged the company as consultant till November 13th, 2020. So his term of office ended on 30th September. Then he was employed as a consultant. What they
Correct.
paid me is only what was statutorily due to me during the time that I was in employment. I can produce the details, my lord, what they given me, the breakup for that. Your lordships may see at page 42, point number 2.
Yes, Mr. You come to page 41.
Gratuity, leave and cash.
No, in page 41. Other than the above, while not be entitled for or claiming any other pay and allowance, except statutory implied benefits such as gratuity, leave encashment, etc., as full and final settlement.
I have paid this. I have years. Years of the compensation. But when they get by, and when we pay this, the contract of the end of the department is superseded what the references. When he has undertaken not to pay the again he makes a claim. What is the sign for this payment?
Now, does it make a claim towards gratuity and other things?
Make sure it's clear attachment to make sure it's not there. I mean, page number 50 50 of the A is towards 3 months notice period. B is towards leave encashment. C is towards damages. After 8 months,
Correct, but leave encashment is his entitlement. Leave encashment is his entitlement. Correct. If there's a calculation error,
that also he had asked. Next page, 81 will write 81, 82, 83. 81 has made us 49 is picked up. 82 has picked up 14. 83 has written by there is no dispute with regard to the payment rate.
My lord, whether, my lord, in a 227 jurisdiction, my lord, this is an ad interim order made unless the court's order is found to be without jurisdiction. Whether in 227 jurisdiction, the Honorable High Court should interfere is a question.
but there's no remedy available.
No, remedy, Andre, it's an
Order
interim
passed
order,
to
my lord.
trial court.
My lord, all interim orders, my lord, are interim subject to final determination of the dispute. But the object of Article 227 is not to interfere with interim orders, my lord. unless it is shown to be something which is outside jurisdiction. My lord, in page 50 of the plain, he says that he is entitled to this amount. Now, my lord, what they paid me also, the breakup is available, my lord. If your lordship should see at page number 42.
Yes.
The first check, 3,65,000 is towards consultancy for month of October, November. Second one is 4,03,000 towards gratuity. And the remaining is 36,200 rupees towards welfare fund.
Yes.
Now, if I'm asked to deposit this, I'm out, I've now finished my tenure. I have no job. I'm entitled to gratuity. Even if my suit fails, they can't ask for this gratuity back and this other benefit back. And this amount of 365, what is paid to me is for the duration when I served. Now the question is whether I'm entitled to additional amount, which I have stated, my lord, in the plaint.
The consultant gratuity
before he taken on consultancy, he was a full-time employee as a gentleman. My lord, it happens. After
the settlement is for the term prior to his appointment.
No, my lord, he finished his tenure as general manager. Then he was appointed as a consultant. Then, my lord, he was fired. Now, when at that time, they paid him all his statutory dues because at the time he retired, he didn't take the gratuity was not paid to him then.
This is before his employment as a consultant.
Yes, before his employment. That's why I showed, my lord, the appointment letter shows that he was appointed as a general manager.
Tell me, is there any policy in your company which provides for payment of gratuity to a consultant? Then?
No, my lord. I'm sorry, my lord.
Then it is his entitlement. Right, that is in respect of something else. So that is his gratuity is not something that you give free. It's a statutory benefit. Leave encashment is a statutory benefit. Correct. So you have paid it. Sorry. The dependent in OS number 3250 of 3239 3250 of 2021 3850 of 2021 on the file of the so and so court has filed this petition agreed by the order dated 19/7/2022 passed therein, by which an application filed by it for a direction to the plaintiff to refund rupees 8,05,216 was rejected. Full stop. Next, the suit in OS number 3850 of 2021 was filed for recovery of a sum of rupees 10 lakhs towards the 10 lakhs towards the 3 months wages no, that's a question of fact. You please answer. 6 lakhs towards the 3 months wages payable to the plaintiff prior to terminating the services of the plaintiff and towards the leave encashment of 45 days and damages for wrongfully obtaining, for forcefully obtaining a letter of undertaking, forcefully obtaining an undertaking of full and final settlement of the dues of the plaintiff. Stop. Next para. The defendant contested the suit and claimed that the plaintiff is not entitled to any of the reliefs in view of the full and final settlement of all the claims of the plaintiff. Full stop. During the pendency of the suit, an application was filed by the defendant for a direction to the plaintiff to redeposit the sum of rupees 8 lakhs so and so that was received by the plaintiff in full and final settlement of his dues as acknowledged by the receipt dated 19/12/2020. Stop. The trial court, in terms of the order impugned herein, rejected the said application on the ground that the amounts paid under the full and final settlement were in fact the entitlement of the plaintiff prior to he being superannuated from the services of the defendant. Stop. Being agreed with the said order, the defendant has filed this petition. The learned counsel for the defendant submitted that the plaintiff, having once received his entitlement in full and final settlement, cannot now turn around and claim that he was entitled for a notice period, entitled for 3 months salary in lieu of the notice period, and also that he was entitled to certain amounts towards leave encashment and damages for forcefully obtaining the full and final settlements receipt. Full stop. He relied upon the judgment of the apex court in the case of so and so. Case number 90. 19 is the full stop. Per contra, the learned senior counsel representing the plaintiff submitted that the amount paid towards full and final settlement included the statutory entitlements such as EL encashment, gratuity, welfare fund, etc., which were the entitlement of the plaintiff, and the same which was the entitlement of the plaintiff, which was settled by the defendant. He submitted that the defendant cannot term these payments as unauthorized and therefore cannot insist the plaintiff to repay the said sum. Full stop. I have considered submissions made by the learned counsel for the parties. Next para. The plaintiff was employed as a vice president of the defendant, vice president human resources of the defendant from 18/9/2013 to 30th September 2020. Full stop. He was thereafter engaged as a consultant till November 13/11/2020. Full stop. Consequent to such resignation, the plaintiff and the defendant entered into an understanding in terms of which, the defendant had agreed to pay consultancy fees to the plaintiff. Full stop. It specifically set out the following, page number 41, pencil mark. Full stop. It is therefore evident that the plaintiff was entitled to the gratuity payable, leave encashment payable to him. Full stop. The receipt for full and final settlement, which was executed by the plaintiff on 19/12/2020 was in respect of the leave encashment as well as the gratuity. What is this 3 lakhs towards leave encashment or consultancy? Was towards his leave encashment as well as towards his gratuity and welfare fund. Full stop. This also included the consultancy fee for the month of October and November 2020. Full stop. It therefore cannot be claimed that this was a wrong payment made by the defendant to the plaintiff. Full stop. The plaintiff made was towards the consultancy provided as well as the leave encashment and the gratuity as well as the welfare fund to which the plaintiff had contributed. Full stop. Therefore, the trial court was justified in rejecting the application filed by the defendant. There is no merit in this application.
Hearing for the petition, my lord. My lord, it is this petition arises out of the FDP proceedings. Suit for partition was decreed, my lord, between the father, son, and daughters.
Yes.
My lord, suit was decreed on 7/12/2015, my lord. So they filed the FDP proceedings, my lord. Daughters have filed the FDP proceedings before the trial court, my lord. Then, my lord, in the FDP proceedings, commission report has the properties measures 16/21.
Yes.
The trial court rejected the commission's report.
Now, what does the commission report say?
Commission report, they are divided 4/21, 4/21. It could not be.
Not partible. It is not partible.
Not partible. That's reject. Then, my lord, the application under IR6 has put the property to public action. So the father and son who are residing there, they want to, my lord, to pay the amount to the share of the daughter. That is first petition is the father and the second petition is the son. And respondents are the daughters of the petitioner number 1. So because they are residing there, the petitioner number 2 is eking out his livelihood by running auto. So the court straight away ordered for public action without giving opportunity to pay amount to the respondents towards their share because they are residing separately with their husbands. So this is only a residence that is available.
Let there be an auction conducted amongst the sharers.
Your lordship, that could be done. But here, what is a public action has been ordered? Saying that I have not filed any objection. I have filed my objection.
This issue notice. In addition, the learned counsel for the petitioners is directed to serve the counsel who represented the respondents before the final decree court. Based on 30th September. Until then, further proceedings in FDP 6/2016 on the file of the so and so court is stayed.
Please, brother.
Then direction. What is the stage of the suit now? How old is he? How old is your client?
70 years.
70 years. From 2020, he was 60 years. In 2020, he was 60 years. In 2022, he became 70 years. Please come to page number 11. Page number 11 of your. Prabhavati. What is the stage of the suit now? You have filed your written statement. Issues are framed. What is the suit property? What is the suit property? Mister, what is the suit property? Building. Facts ಎಲ್ಲ ಏನ್ ಬೇಕಾಗಿಲ್ಲ. Partition, mean profits, separate possession. Injunction suit ಅಂತಿಲ್ಲಪ್ಪ, ಇದು ನೋಡಿ partition ಇದೆ. Mister, please come to page 28. 28 ಏನಂತ ಹೇಳಿದ್ರು? ರಿಲೀಫ್ ಏನಂತ ಇರೋದು? Why do you say it's a suit for party injunction? Clean ಓದ್ಕೊ ಬನ್ನಿ. Partition suit ಅಲ್ವಾ ಇದು? It's not a suit for partition. Please, where is the plaint? Where is the plaint? Where is the plaint? Page number 11. What is the relief sought for? Page number 31. Please read. So suit is for partition, not injunction. Purport. The petition is filed for a direction to the trial court to dispose of the suit. Filed in OS number 6504 of 2020. The Learned Counsel for the petitioner submits that the suit is filed in the year 2020 and that the trial court is yet to hear the application filed by the plaintiff. So he submits that the petitioner is 70 years old and therefore the trial court may be directed to dispose of the suit. Next para. The Learned Counsel, next para. The suit is filed for partition, separate possession of the plaintiff share in the suit's property. The suit is filed. Suit is still at the stage of hearing the interlocutory application. Therefore, this court cannot issue any direction to dispose of the suit as sought for by the petitioner. Hence, the petition lacks merit and is dismissed. What is the request? What is the application filed? At what stage this was filed? At what stage was this filed?
The request for the price of substituting for the defense evidence and I have filed all the documents were produced in another, or the center of the approval are the same. At the time, I have filed an application for the college. The other side also not filed applications. They itself are ready to produce the documents and details.
What are those documents?
All the title deeds, title deeds.
You do not have these documents, is it?
All the documents are produced in another court.
No.
I have received the cases as well. Was
No.
not of 96 of 15.
Issue notice. In addition, the Land Council for the petitioner is directed to serve the Land Council who represented the respondents before the trial court. Including stay of further proceedings in invoice number 25170/2017 in the next date of hearing.
That is operating in otherwise it was right now. In spite of that, the trial court is not accepting the application. The 39 group B days, even within 30 days with expert.
You have to file statements within 90 days. Within 30. All statements have to be filed within 30 days. Is it filed? Amendment should not be filed after the issues are framed. Is it done? Don't quote these procedures, mister. Then we hold these procedures against you. No, don't ever quote these procedures against the court. Don't tell the court what the court should do. Written statements are filed at the time of arguments. Amendment applications are filed at the time of arguments. Why is it allowed? Don't press the procedures against the court. Issue since the petitioner herein has sought for a direction to the trial court to dispose of IAS 3 and 4 filed in OS number 3058 of 2022. Hence, notice to the respondent / plaintiff is dispensed. Next paragraph. The Learned Counsel for the petitioner submits that the suit in OS number 3058 of 2022 was filed for partition separate possession of the plaintiff's 1/5 share in the social property. To stop, an application was filed by the plaintiff to restrain the defendants from alienating the social properties. And what is the other one? And for injunction to interfere with the possession of the plaintiffs in the social property. Full stop. The trial court had passed an interim ex parte order of injunction on the said applications. Full stop. The petitioner claims that it was arrayed as defendant number 5 in the suit and that it had advanced loan on the security of the social property and that it had initiated proceedings under the Surface Act for recovery. Full stop. He submitted that though he had filed an application for vacating the order of interim stay, the trial court, though he has filed his objections to the said application, the trial court is not considering the said applications. So as a result, he contends that the petitioner is unable to proceed with the proceed to recover the amount under the provisions of the Surface Act. We therefore prays that a direction be issued to the trial court to dispose of the suit applications expeditiously. Next para. If the trial court had granted an order of interim injunction, it must have considered the same after the concerned defendant entered appearance and filed his objections to the said applications. In the case on hand, the interim injunction was granted on 4th of May 2022. The defendant number 5 has entered appearance and filed its objections to the applications on 4/7/2022. To stop in that way of the matter, it is necessary to direct the trial court to consider the application and pass appropriate orders. Which against the following order, the petition is allowed. The trial court is directed to consider the applications filed by the plaintiff. The interim applications filed by the plaintiff and pass appropriate orders within a period of 2 months from the date of receipt of a certified copy of this order. Yes.
Number 7.
Section 10. 10. What is the suit? Earlier suit. What is the first suit number? Who had filed that? Swami had filed.
On the very same day, what they did, they entered into a registered agreement. ಅದು ಬರೀ ಆಗಿಬಿಟ್ಟಿದೆ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಮಾಡೋದಕ್ಕೆ ನಾವು ಮೋಸ ಅಂತ ಏನು ಗೊತ್ತಾಗ್ತದೆ ಫೈನಲ್ ಕ್ಯಾನ್ಸಲೇಷನ್ ಅಪ್ಲಿಕೇಶನ್ ಅವರು ಕೋರ್ಟ್ ನಲ್ಲಿ ಎರಡು ಪ್ರಾಪರ್ಟೀಸ್ ಫಾರ್ ಡಿವೈಡೆಡ್ ಟು ಸೂಟ್ಸ್ ಸೇಮ್ ಸೂಟ್ ಎರಡು ಒಂದು ಮತ್ತೊಂದು out of 30 out of 20 registered agreement also. Unregistered agreement also very same day two agreements registration agreement. They wanted to now enforce the second agreement. Right before the properties are different. Properties are not different.
Are you the owner of this property?
Yes, I am the owner of the property. I am the owner of the property 37/5 and 31/5. 31/5 and 32/5. Enter into the reversal calculation of 22. 1,78,000 Two brokers. One respondent Rajan and Malaysia broker. ಅವರು ಏನು ಮಾಡಿದ್ರು ಅನ್ರಿಜಿಸ್ಟರ್ಡ್ ಅಗ್ರಿಮೆಂಟ್ ಗೆ ದುಡ್ಡು ಕೊಡೋದಕ್ಕೆ ಇನ್ನೊಂದು ರಿಜಿಸ್ಟರ್ಡ್ ಅಗ್ರಿಮೆಂಟ್ now we came to know that they are not applying the terms and that's why we filed a suit for cancellation of the unregistered agreement, also the registered agreement. I will hand over to you. The unregistered agreement is
You have sought for returning of that registered agreement. He has sought for special performance. Both of them will have to go together. Where's the question staying?
That's what I also indicated to the now question. ಅದು ಬೇರೆ ಬೇರೆ ಹೋಗ್ತಾರೆ.
ಆಯ್ತು ಒಂದು ಕೋರ್ಟ್ ಬೇಕಾದ್ರೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡೋಣ ಅಷ್ಟೇ. How can a specific performance be stayed?
Cancellation of those agreements.
How can that be stayed is what I'm asking. Can go together.
Cancellation of those agreements.
ಅದೇ ನಿಮ್ದು ಕ್ಯಾನ್ಸಲೇಷನ್ ಆಗುತ್ತೋ ಇಲ್ಲ ಅಂತ ನೋಡ್ಕೊಂಡು ನಂತರ ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಪರ್ಸ್ಯೂ ಮಾಡ್ಬೇಕಾ? ಬರ್ಕೊಳ್ಳಿ. ಈ ಎರಡು ಒಂದೇ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದೆಯಾ ಎಲ್ಲಿದೆ? Is it before the same court? ಎರಡು ಅಲ್ಲೇ ಇದೆಯಲ್ಲ. You direct the court to take both the suits together. ಹಾಕಿದಾರ? We direct the trial. The plaintiff's invoice number 234 of 2015 have filed this petition agreed by the order dated 17/6/22 passed therein. Output ಹಾಕಿರೋದಾ? ಬೇರೆ the defendants invoice number 311 of 2015 I filed this petition challenging an order dated so and so passed therein by which their application for stay of the suit under section 10 of the Code of Civil Procedure was rejected. Next para, the short facts necessary for consideration of this petition are that a suit invoice number 234 of 2015 was filed for the following reliefs. Page number 7. Yes, sorry, page number 32. Following this, comma, another suit invoice number 311 of 2015 was filed for the following reliefs. Page number 39. Full stop. Both the suits related to the land in survey number 31/5 of Hoskote village, Arohalli, Hobli, Kanakpura Taluk. Full stop. Next para. The petitioners, being the defendants in invoice number 311 of 2015, sought for stay of the proceedings in invoice number 234 of 2015. Sought for stay of proceedings in invoice number 311 of 2015 until disposal of the suit invoice number 234 of 2015. The trial court, in terms of the impugned order, rejected the application as the relief sought for in both the suits were different. Full stop. Being agreed with the said order, comma, this writ petition is filed. Next, the learned counsel for the petitioner submits that unless the relief sought for invoice number 234 of 2015 is considered, the question of grant of the relief invoice number 311 of 2015 does not arise. Next para. I consider the submission made by the learned counsel for the petition. It is not in dispute that both the suits related to the land bearing survey number so and so in so and so village. Stop. The relief sought for in both the suits were different and were not intended different. Full stop. The relief invoice number 311/2015 did not depend upon the outcome of the suit invoice number 234 of 2015, and both of them had to be dealt with together, as the defense invoice number 311 of 2015 was nothing but the assertions made in the plaint invoice number 234 of 2015. In that way of the matter, comma, the trial court was justified in rejecting the application. There is no merit in this situation. The same is dismissed. Next para. Since the suit invoice number 311/2015 and 234 of 2015 relate to the same property, comma, this court considers it appropriate to direct the suit invoice number 234 of 2015 to be transferred to the court where OS number 311 of 2015 is filed, is pending consideration. If both the suits are before the same court, then both the suits shall be tried together by recording common evidence and by passing common judgment. Yes. No. No. Yes, Prakash. Yeah, partial decree is there, no? What is the meaning of?
He says that the plaintiff shall and now, after his insistence to pay 40, they are not drawing up a very application saying that I cannot pay the 40 of that.
Where's the plaint? Where's the petition? Yes. So what is the application no filed? Suit is, ejectment suit is decreed.
But degree is not first for part of not be having been paid on rupees 31 lakhs. Now the direction is to the plaintiff refund 31 lakhs. There is no counter claim in the return statement.
And then you have to challenge this appeal, then judgment na challenge ಮಾಡಬೇಕು.
I am not agreeing to the
But counter claim is then just.
now
Please have a look at this. ವಾದಿ 31 ಲಕ್ಷ ಹಣವನ್ನು ಕೊಡಬೇಕಾಗಿದ್ದು
what I said in my application. Over is ejected and there is a judgment. Holding that I mentioned this is the judgment on my claim, and I said I am going to this degree for this.
where's the counter claim ಹೆಂಗ್ ಮಾಡಿದ್ರು ಮತ್ತೆ? How did the court pass a counter claim?
This is not the no issue because of what of the punishment for no issue. The symptom for and his suit for present performance is that's going on. My guess is that what court says is worship
Issue notice, let us issue notice. Muniyappa.
Commercial report. I filed an application with the commercial court. I know that this is the arrangements of performance. For specific performance. For the return of the money. For the according to our idea. by the not paid for. According to the
Then commercial suit engaagತ್ತೆ sir.
that's what. It's not a commercial, that is my contention.
Alla, suit application rejected.
My application is rejected. It is a commercial suit.
ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
Filed before this application.
Sir, this application is filed by the defendant to reject the plaint as barred by law because this is a commercial suit ಅಂತ ಹೇಳಿದ್ದಾರೆ. So judge,
I have done not a commercial. I am the argument.
suit is filed before the commercial court. Sir, it is transferred to the commercial court.
My contention is that is not a commercial suit, it is a civil suit.
When did you file that application?
The application I have filed by not.
After it was referred, transferred. ಅದನ್ನ ಹೇಳಿ. After it was transferred. You notice. Notice serve ಮಾಡ್ಕೊಂಬಂದು. Learn counsel for the. Learn counsel for the petitions directed to serve the learn counsel who represented the respondent. List on 29 September. Actually serve ಮಾಡ್ಕೊಂಬಂದು. Other proceedings in the suit in OS number so and so is state of it.
I'm appearing for the petitioner. Petitioners are the defendants before the trial court, my lord. The petitioners challenging the annexure G dated 24/9/2021 and annexure J dated 7/4/2022 passed an order granting ad interim injunction in favor of the plaintiff in respect of the suit schedule property. Suit is for in a injunction suit, my lord. The case of the plaintiff is that they have purchased the suit schedule property from the grandfather of the petitioners. That the contention of the defendants, my lord, that is that grandfather of the plaintiff has not sold the property. That that revenue documents are continued with their in their names till his death, and after the death, that revenue document continued in their name. So further, my lord, it is the contention of the petitioners that the plaintiff to knock off the property by giving the wrong boundaries have filed a suit.
Yes.
Therefore, wrong boundary. Therefore, that is not the property belongs to the plaintiffs. The trial court, though that come to the conclusion there is a dispute with regard to identity and the title, is granted the interim order, my lord, the interim injunction, my lord. When there is a dispute with regard to title, that injunction suit itself is not maintainable, my lord. Though the trial court come to the conclusion in his order, as prima facie, only it's found a prima facie case on the basis of the sale deed produced by the plaintiff.
Yes. How is this Puttamadappa related to you?
It's grandfather, my lord.
Grandfather. And he sold it in the year 1964.
64. But actually, they have mentioned the survey number as 28. But the said survey number has been ported in the 1959 itself as 29/2 and 29/3.
Yes.
Further, my lord, when the sisters of the petitioners filed a suit for partition, they have mentioned the suit schedule property as proper with proper boundaries. At page number 42, my lord, that the suit filed in that.
Did grandfather have any other property other than this?
Pardon, my lord?
Did your grandfather have any other property other than this?
Two properties were there, my lord, 28/2 and 28/3.
Yes. What is the suit property?
food property is a site, according to them, this is a vacant site property. Measuring 55 into 105.
Yes, Prakul, the defendant invoice number 918 of 2021 on the file of the so-and-so court, on the file of the 11th additional civil judge and JMFC Mysuru has filed this writ petition challenging the correctness of the order dated 24/9/2021 passed therein, as well as passed therein granting interim injunction restraining the defendants from interfering with the possession of the plaintiffs, as well as the order passed to the appellate court in MA 82 of 2021 dated
7/4/2022.
7/4/2022. Next para. The suit invoice number 918 of 2021 was filed for perpetual injunction in respect of a property measuring 55 feet into 105 feet, lying within survey number 28 of Chuncharayana Hundi, Jaipura Hobli, Mysore Taluk. To stop, the plaintiffs claimed that the suit property was sold to the second plaintiff on 14/7/1964 by Sri Kare Hundi Uttamadappa, who was the grandfather of the defendants. Full stop. The plaintiffs claimed that they were in possession of the suit property and that the defendants, taking advantage of the fact that the revenue entries continue in the name of their grandfather, attempted to interfere with their possession. Full stop. The plaintiffs also sought for interim injunction to protect their possession during the pendency of the suit. The defendants denied the execution of the sale deed, as well as the fact that execution of sale deed on the ground that survey number 28 was bifurcated and reassigned as survey number
28/2 and 28/3.
28/2 and 28/3, and therefore, the property claimed by the plaintiffs do not exist. Full stop. Next para. Since the case presented a triable issue, the trial court granted an order of injunction restraining the defendants from interfering with the possession of the plaintiffs in the suitable property. An appeal referred therefrom by the defendants in MA 82 of 2021 also met the same fate. 21 was dismissed, and the appellate court confirmed the order of injunction, interim injunction. To stop being agreed with the said order, the present petition is filed. Learned counsel for the petitioners submitted that the suit property did not exist and that the boundaries furnished by the plaintiffs were incorrect, and therefore the trial court as well as the first appellate court should not have granted the interim relief sought for by the plaintiffs. Next para. When the facts presented before the trial court indicated that the grandfather of the defendants had conveyed the suit property to the plaintiff number 2 in the year 1964, the contention of the plaintiffs that the defendants were interfering with their possession, appeared probable, and therefore the trial court held that a tribal case was made out by the plaintiffs and hence granted order of injunction, which was upheld by the appellate court. This court does not see any error in the exercise of jurisdiction by the trial court and the first appellate court. This resolution lacks merit and is dismissed. Yes.
Much obliged.
Yes. When did you enter possession? 15/3/20. Correct. What can be done? Auction is already scheduled. No, auction has not taken place, it is scheduled. Madam, date, place and time of auction 7/9/2022. Was the auction held or not? First you should know the outcome. First hear what has happened to the auction. Here, put it in writing. Please put it in writing, madam, that auction was not held. We'll consider. Put it in writing. Because learned counsel for the petitioner submits that the petitioner was a tenant who was inducted into the premises in question, which was offered as security for a loan raised by the owners. She submits that the property was put up for auction on 7/9/2022. However, there were no bidders and therefore the auction was abandoned. So there is no next for a perusal of the written petition does not indicate the particulars of the auction held on 7th of September 2022. Hence, the learned counsel for the petition is granted to furnish details about the auction that was conducted on 7/9/2022. List on 21. Really, I haven't started to put that. Madam, they cannot take, there's a procedure for taking possession. Yes. It's not 7 days. They have to go before the concerned magistrate. Section 14 of Petition Act. You should produce all those details, madam. You cannot simply say that. Suppose if there's an order by the magistrate, please listen to me. Suppose you should find out. You should find out whether there's any proceedings under section 14. You should find out whether you have been dispossessed. In addition, she shall also declare the pendency of any proceedings under section 14 of the Surface Act, and if yes, the stage of the said proceedings. Yes. September 21st. Page 32.
When the court commissioner has I wrote, he said he wrote it in I can't do it because we can't just prepare that part of the our objection for application is
To see whether the what I can
cannot address the request. In the rise of repair, she may be the first damage to the road from water and only honest. What we request is any computer evidence.
the leakage is from your floor. The leakage of water is from your floor.
Oh, so you want or in the don't terrace. Don't terrace. You are
Then imploring a
once you whatever she
sir, you correct it. ನಿಮ್ಮನೆ ಒಳಗೆ ತಾನೆ ನಿಮ್ಮನೆಯಿಂದ ಲೀಕ್ ಆಗ್ತಿರೋದು. It is water is leaking from the. So let the advocate commissioner find out. Let him go and let him go and say what he has found it. Sir, let him go and see what can be seen. Not necessary, sir. Let the lawyer go and report what he has seen. First, let him give the report. Why should he undertake the repairs? Let him report. No, let him go to the spot. Let him find out. Yes. Same order you produce in two places. Why? Are number? Papa, why have you produced page number 29? Correct. Purple. The respondents in FDP 9 of 2021 on the file of the fourth additional senior civil judge and James Mysore have filed this petition. I have filed this petition challenging an order dated 3/9/2022 passed therein by which an application filed by the petitioner in IA number 11 was allowed. and an advocate commissioner was appointed. Next para. FDP 9 of 21 was filed to enforce a preliminary decree passed in OS number 1135/2006. Full stop. During the pendency of the final decree proceedings, the petitioner, the respondent number 1 filed an application under section 151 of the Code of Civil Procedure to permit her to undertake repair of the suit property by repairing the northern side staircase compound to lay a water sump due to the leakage of the existing sump and to repair the ceiling of the ground floor terrace portion due to seepage of water from the first floor entrance side. Full stop. The trial court in terms of the final decree court in terms of the order dated 17/8/2022 allowed the application and directed the respondent number 1 to file an application for appointment of a court commissioner for assisting the court court commissioner. Full stop. Later, an application was filed by the respondent number 1 for appointment of a court commissioner. Full stop. The trial court in terms of its order dated 23/8/2022 appointed an advocate as a court commissioner to visit the spot and submit his report. Full stop. The said order is challenged in this petition. Learned counsel for the petitioner submits that the respondent number 1 is trying to disturb the construction already put up in the first floor by taking advantage of the order passed by the final decree court. The petitioners have not challenged the order passed by the final decree court on IA number 10. The final decree court has noticed that the leakage of water into the premises of the respondent number 1, as well as the leakage of water from the water sump, and therefore felt it appropriate to permit the respondent number 1 to carry out the repairs. Full stop. It is only for the limited purpose of ensuring that repairs are done that a court commissioner was appointed. Full stop. This court does not find any error in the order passed by the trial court. Hence, the petition lacks merit and is dismissed. Yes. So you're not challenging the order passed on IA number 10. No, IA number 10 is not challenged. Order on IA number 10 is not challenged. Sir, advocate cannot do. Can an advocate do it? The repair the advocate malakagutta. Advocate, he will look into the way in which it is done. Or seri ಮಾಡ್ತಾರೋ ಇಲ್ವಾ ಅಂತ ನೋಡೋದಕ್ಕೆ. Next. Challenge it. ಮಾಡಿ. Learned counsel for the petitioner has filed a memo that the petition has become infruct. The memo is placed on record. ಯಾವುದು? IA 2 of 16 is filed to recall the order dated 7/4/2016. This is number 13 of mine. 7/4/2016. The cost shown for non-appearance. IA 1 of 16 is filed for conversion of delay to recall the order dated 7/4/2016. The cost shown for the delay is accepted, hence IA 1 of 16 is allowed. Next para. IA 2 of 16 is filed to recall the order dated 7/4/2016. The cost shown for the default. Cost shown for the default. In not complying the office objections is accepted. Hence, the order dated 7/4/2016 is recalled. The writ petition is restored to file. Full stop. The learned counsel for the petitioner has now filed a memo to withdraw the writ petition. The memo is placed on record and the petition is dismissed as withdrawn. 1 week time is granted to do the need. Rectification of the extensions in there. Mr. Vasantappa. Mr. GN Sankarnath. ಏನ್ ಹೇಳಿ ಫ್ಯಾಕ್ಟ್ಸ್ ಮೇಲೆ ಹೇಳಿ.
Now, we wanted to accommodate the client, accommodate the statement.
$15 years ಇರುತ್ತಾ 10 years ಅಲ್ವಾ? Is it 15 years or 10?
First transaction not after 20 years. Then not the act called this is the implementation. That not the so not
Full judgment ಇದೆಯಲ್ಲ. Is it granted by the land tribunal or what? ಅವ್ರು ಹೇಳಿದ ಸರಿ. Just check whether it is under the Land Reforms Act.
Yes, yes. It is stated in the additional.
Right, sir. ನಿಮ್ ಪ್ರಕಾರ ಹೇಳಿ. Is it granted by the Land Tribunal?
Yes, yes. Granted by the land. All the return statement are additional
Under what act?
under the Land Reforms Act.
Under what act it is granted?
The Land Reforms Act.
This Mr. Vasantappa. Vasantappa. Mr. GM Shankar Nag. IA 1 of 22 is filed for extension of the interim order. There is no representation for the respondent. So since the petition involves substantial question of law that needs to be considered, IA 1 of 2022 is allowed. The interim order granted earlier is extended till the next date of hearing. List after service of notice. List after service of notice to respondents. Sir, list after service of notice to the respondents 2 and 3. Yes. Interim order is extended till the next date of hearing. The process counsel for the petitioner submits that they have taken out process. Ivata, they have taken it today. Today, office is directed to check, verify, and proceed. No, there is some dispute with the address if that is the case. Service of no. Interim order is extended till the next date of hearing. What are these office objections?
Carry forward to the lower, despite they having like higher reach. So the same market is taken here. Our low ranking is given. Respondent has been money now.
The office objections is kept open. Yeah, yes.
This
For rejection of the plaint. How is the writ petition maintainable? CRP ಬರ್ಬೇಕಲ್ವಾ? Then you withdraw it. Legal counsel for the petitioner submits that this writ petition is filed against an order allowing or rejecting the application filed under order 7 rule 11C of the Code of Civil Procedure. Stop. Since the allowing the writ petition would result in disposal of the suit, a revision petition under section 115 of the Code of Civil Procedure is maintainable and not a writ petition under Article 227 of the Constitution of India. Hence, the petition is dismissed as not maintainable. Liberty is reserved to the petitioner to file a revision petition. Office is directed to return a certified copy of the impugned order after retaining a photocopy of this case. Yeah, R5 then corrected the address. The notice issued to the respondent number 5 has returned unclaimed. Stop. It is seen that the address mentioned of the postal cover as well as the address mentioned in the cost address of the respondent number 5 mentioned in the cost title are the same. Cost title of the trial court are the same. Hence, notice to respondent number 5 is insufficient. Office is that to show the name of the respondent number 5 in the cost list as served. 1 week time is granted to pay. Process to issue notice to the respondent number 4.
That this is only with regard to an appointment of commissioner.
Whatever.
4. Handwriting expert hacking.
Who is the respondent number 4? Is the respondent number 4 contesting the court?
Respondent number 4 is one of the legal aid that I could not secure the vocal, therefore I did not appear. So
ಸಿಕ್ಕಿದ್ರೆ ನೀವು ಹಾಕಿ ಅಷ್ಟೇ.
date 2010.
For what? Yes. Gaurav, I can't hear you. If there is a mistake, then what has to be done? The decree has to be set aside. So the repetition has to be allowed. You file a memo to withdraw the suit. Let us see. Please wait. Let him complete. Yes. File a memo. Yeah, what is the difficulty if he withdraws the suit? What happens if he withdraws the suit? How are you affected if he withdraws the suit? How are you affected if he withdraws the suit? Whatever. So he is withdrawing the suit. Everything he is putting a quietus to everything. Then counsel for the respondent number 1 to 4. Respondents 1 to 4 submits that his client is interested to withdraw the suit filed before the trial court. The learned counsel for the petitioner seeks time to ascertain whether the petitioner has any objection for withdrawing the suit. Objection if the suit is withdrawn. Mr. When do you want it? List on wait for him. Yeah. Please have set out the note on move ಮಾಡಿ ತಗೊಳ್ತೀನಿ. ಇದೇನಾ ಆಯ್ತು ವಿತ್ಡ್ರಾ ಮಾಡ್ತೀವಿ ಅಂತಲ್ಲ ಸೀರಿಯಲ್ ನಂಬರ್ 20. What do you want? That is Sarad ಅಂತ ಆಗಿದೆ. Extend to the next date and come on. Please take out process today. The interim order will automatically expire. ಅದಕ್ಕೋಸ್ಕರ ಒಂದು ವಾರ ಟೈಮ್ ಕೊಟ್ಟಿದೆ. Interim order ನೀವು process ಕೊಡದೇ ಇದ್ರೆ interim order vacate ಆಗುತ್ತೆ. The memo is filed to withdraw the petition. In view of the memo, the petition is dismissed as withdrawn. Pass over. Demand. List after service of notice to respondent 1 and 2. Interim order idea. Same order. What's your name? What is your name? Mr. Raghavendra, initial. Mr. S.C. Raghavendra undertakes to appear for the respondents 1 and 2. Full stop. His memo of undertaking is filed. His memo of undertaking filed before the court is accepted. Office is directed to show the name of Mr. S.C. Raghavendra as the advocate for response 1 to 5, 1 to 3. List after service of notice to respondents 4 and 5. Is the interim order idea? Yeah. Interim order is extended till the next date of hearing.
Petitioner, my lords, interim order may kindly be extended, my lords.
After service of notice to response 1 to 15, interim order is extended till the next date of hearing.
Much obliged, my lords.
Mr. Mohan Chandra. What are the office objections? ಇನ್ನ ಕಟ್ಟಿಲ್ವಲ್ಲ ಮೊನ್ನೆ ಕಟ್ಟಿದ್ದು 8ನೇ ತಾರೀಕು ಪುಟಪ್ ಆಗಿದೆ. Have a look at it. So this is 8/9/2022. The office has put up a note that court fee to be paid. Check ಮಾಡಿ pass over. ನೋಡಿ ಚೆಕ್ ಮಾಡಿ. Mr. Dodwad. R2 to R10 represented by whom to be stated. Nature of respondent 2 to 10 to be stated. Who are the respondents? 2 to 10, right? Yes. What is the application now, sir? Trial court has rejected this application. Why you are not taking steps then? Why you haven't taken steps? Why, if the addresses are correct, why is this notice not getting served? The addresses are correct. Why is the notice not getting served? You undertake to serve and summons to all of these respondents. Different number 5. Network 18. Who is different number? Wild news. Earlier. Take hand summons to respondent number 5 then. No, but you should ensure that notice is served to all the respondents by the next date of hearing. Only then will they extend the interim order. By the next date of hearing, you should ensure that all of them will be served. Purport. Issue notice. Issue notice in addition, the learned counsel for the petitioner is directed to serve the learned counsel who represented the respondents before the trial court. Full stop. Insofar as respondent number 5 is concerned, the learned counsel for the petitioner is directed to take out hand summons by the next date of hearing. Interim order granted by the trial court on so and so date is extended till the next date of hearing. It is made clear that if the notice and hand summons is not served on the concerned respondent by the next date of hearing, the interim order extended today will stand automatically dissolved. This form date. You have to take out notice to all of them and they have to issue notice. In addition, the learned counsel for the petitioner is directed to serve the learned counsel who represented the respondent number 1 before the trial court. You shall take out hand summons to the other respondents. It is made clear so on so on. Yes. 29 September. Here the IA for vacating. Yes, Mr. Gangadhar Ital. ಏನಾಗಿದೆ Mr. Gangadhar Ital. Stay ಆಗಿದೆಯಾ? 22 ton of stay. Who is his petitioner? He is a purchaser. Petitioner is a purchaser. Allow ಮಾಡಬಹುದಲ್ಲ? Petitioner is purchased from whom? From the plaintiff. So the purchaser is purchased from the plaintiff. So therefore, what is wrong? There is no representation for the petitioner list on. IA 1 of 19 is filed to set aside the abatement of the expedition as against respondent number 10. Since the cause of action as surveyed against the legal representative of the respondent number 10, IA 1 of 19 is allowed, the abatement of the expedition as against them is set aside. IA 2 of 2019 is filed for naming the legal representatives of R10. Notice of this application is served on the legal representatives of R10, who however are not represented, since IA 2 of 19 is allowed and the LRs of the respondent number 10 are ordered to be brought on record. Issue notice on IA 1 of 21 ಹೋಗಿದ್ಯಾ? Issue notice on IA 1 of 21. The required process to issue notice to respondent number 11 and 12 shall be furnished. A memo is filed for dispensing notice to respondent number 11 and 12 as no relief is sought for. In view of the memo, notice to R11 and R12 is dispensed at the risk of the petitioner. Interim order ಏನಿದ್ಯಾ? Yes. Further orders ಅಂತ ಯಾಕೆ ಮಾಡ್ತೀವಿ? Yes. ಹೋಗಿದ್ಯಾ? 3 ಸತಿ ಆಗಿದೆ. The attempts of the court to serve the respondents 3, 6, 13 and 15 through its process have failed. Hence, IA 1 of 22 is filed for substituted service through paper publication in Andolana Kannada Daily, Mysore edition. Full stop. It is stated that this newspaper has large circulation in the place where the respondents 3, 6, 13 and 15 are residing. Hence, IA 1 of 22 is allowed. The petitioner is directed to take out substituted service to the respondents 3, 6, 13 and 15 through Andolana Kannada Daily newspaper Mysore edition by showing the honor before 30th September 2022, showing the date of appearance as 17th October 2022. Yes. What is the IA 1 of 21? IA 1 of 21 is filed to bring the legal, is filed by the applicants who are the legal representatives of the deceased petitioner. Full stop. Since the cause of action has survived the death of the petitioner, IA 1 of 21 is allowed. The counsel for the petitioner is directed to amend the cause title during the course of the day and file an amended to the cause title. Interim order is extended to the next set of hearing. Yes. So Ravi HK. Implement ಅಂತ ಹೇಳಿದ್ರಲ್ಲ. Yes, Ganesha P. Mr. Ganesha P. ನಾಳೆಗಾಗ್ತದೆ. ನಾಳೆ. ಈಗ counsel for the petitioner. Ganesha P. The learned counsel for the petitioner submits that the learned counsel for the cavator has taken an adjournment without informing him in advance. Stop. Hence, listed tomorrow. Yes.
My lord, appear for the petitioner, my lord. Kindly pass over, my lord.
Pass over.
Much.
Mr. Rajana Shetty. ಆಯ್ತು ಗೊತ್ತಾಯ್ತು ಹೇಳಿ ಯಾವತ್ತು ಅಂತ.
Consultation with life and also conservative.
In all these cases, the same issue is involved, is it? Yes, Mr. P. N. Rajesh. You have anything to say? ನೀವು ಎಷ್ಟನೇ ಡಿಪೆಂಡೆಂಟ್ ವರದರಾಜನ್? What about Lokesh BC? B11. Girish Kumar?
B13.
B? Who was the last person who cross-examined this witness? ನೀವು ಮಾಡ್ತಾ ಇದ್ರಿ. ಕೋರ್ಟ್ ಮಾಡ್ತೀವಿ ನೀವು ಮಾಡದಿದ್ರಿ ಹೆಂಗೆ? somebody sitting in US is, they laugh at our system. Correct. So court is ready to record evidence.
Subsequent development ಮಾಡಬೇಕು. ನಾನು ಒಂದು ಸಣ್ಣ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತೇನೆ.
Yes. Which
all their differences the same. That is the prior party. Everybody is looking for
who knows, everybody may not be as well versed and conversant as Mr. Rajeshwar is.
thoroughly consistent. There's nothing that makes it consistent. Everybody's share is that with the prior party.
So we'll stagger it. We'll limit the time for each of them.
We will not have another technical issues.
ಅಲ್ಲ ಆಯ್ತು, ನೀವು 1 ಗಂಟೆ ಮಾಡಿ. Second petition.
Council. City next to the test, EW1. The cross examination of EW1. By integrating the statement of EW1 and by changing the unvarranted conversation, the opposite. Okay. So partition is given 24. Anytime. Then from there on,
who is this advocate?
each question we have to face.
Who
Who
Who is the advocate for defendant number 2?
Appearing here.
Who is the advocate for defendant number 2? That fat person. He's sitting in America. In the, no, but why is this Ram Prasad being allowed there in the consul office? But why should a counsel be there in the room? But why should a counsel be sitting in the room alone? No, there is a. Why is it required to say the truth? Why do you need the assistance of a lawyer?
I was just 12 years old at that time. Just takes 4 or 5 minutes. Then the lawyer sits down to include his letter. I marry a straight time. Otherwise, the other one
What does the court say? Is Mr. B.S. Ram Prasad the counsel on record? Is the counsel on record? Then why does he go? And he travels to US on this. Let him argue. You can have your say later.
Also, the very first leader of the party are the most important actors of one courtroom. Advocates are record of the sentence. Therefore, what the party stand together. So, there is no very important here, the results of the council of the opponent, the topic can be 4 point. Then, counting are two witnesses. The petitioner requires person to the authority to work point. It's a law person. Rules and relevant rules actually cannot be read out of those rules. Even when his cross-examined, however, the right of cross-examination is also the law of opponent. Get them their attention. Because it would carry take the part of the legal Advocates immediately play a role after the court. Furthermore, common fact, cross-examination often involves the matter of which cross-examiner types advocates cross-examining the witness and now to right to expose the underlying of the defense. Which are bound to be partly illegal goods. The advocate was as the vigilance of the advocate is cross-examining does not lie because of the principle here that cross-examiner must not act. He must not receive the court as well as the witness to make cross-examining. Therefore, the presence of the advocate also plays a vital role in the witness cross-examining. The presence of the advocate at no point create a sense of security to helping the defense.
Sir, I have not heard him. Please wait. No, but the advocate can be here. Why is he going to the US? He can sit in the court. He can oppose questions. Why is he going to the US? It might be permissible, but suppose if he prompts the witness, who is going to control him? What record? Yes. Is it recorded? Is it recorded? Oh, is it recorded? Rules provide for recording, but is it recorded? Only there. Recording on the physical recording. It's not a digital recording. Allah. I don't understand why should a lawyer who is a part of who is in the team of lawyers assisting the witness, why should he travel to the US? No, why should he travel? Please tell me.
Because the witness is 88 years old. And he has comorbidity. He cannot work on his own. And his hands are shaking. That's the condition of the witness.
So the lawyer will go and hold her, is it? Yeah, because the 88-year-old person can come to the consular's office. And he can. Yes. No, she can have a lawyer. She can have a lawyer of her own there in Chicago, but not the lawyer who's helping her out in Bangalore. Why should this man go to US? Correct. Let him have a lawyer. Let that person have a lawyer of his choice there. Not here. Correct. The lawyer can stay here. He can be in the court hall. He can oppose questions. The court can always say, don't. Sense of security. Mr. You are what sense of security? What sense of? Correct. What sense of you are entering the Indian consul's office fully guarded? What sense of security? We let him. You keep a doctor on call, do everything, but not the law. But why? But I don't understand why this lawyer has to travel all the way from Bangalore to US, 3 trip.
One more important submission is this.
I'm not completed with. Not completed with it. Please wait.
Where is the environment to do so that I cannot be an advocate for a relative?
That is okay. I did not say that.
Pecuniary interest, not there's a part. I cannot. If there's no pecuniary interest, there's a problem.
Who are you related to this person? Mister, I am asking him, I don't know, why don't you take a seat? Mr. Girish, Girisha. Girish, why don't you take a seat? Kutkoli, Ella Kutkoli, please sit down. Yes. First defendant's wife. Yes. So all the more reason why there could be chances of prompting. Possibility. I said possibility. Yes. Yes, please. Certify. Now, is it done? Let all the lawyers confirm that fact. Is the recording done?
It's done. I love making my work because I've got an application for correction of the position on the basis of account. And with respect to this page number 156, I'm preparing an application for
Hmm. Hmm. You are the defendant number one in the suit. Defendant number two now. Aunt andre? ಅತ್ತೆ. ಸೋದರ ಅತ್ತೆ. So you stand in the line of succession if something happens. ಅತ್ತೆ ಅಂತಿದ್ರಲ್ಲ.
Won't stand a chance to succeed in the problem. Plus 8.2%. All exams time and the fourth working hours.
I think let him be in the remote counter, whatever. He will not wear any mask. No mask. The advocate shall not wear any mask. Let the person having a comorbidity, let him wear a mask, not the lawyer. Allah, but he is an Indian, alwa, Indian in America. So he thinks that a mask is required. Hmm. Hmm.
I mean, they come to the meeting that I will tell you when they don't want the prosecution. It is their evidence system. So they are not relying upon the document. They say it's because they should have forensic this thing to say.
Well, fair enough. Please go ahead with the prosecution.
Every month they get lakhs.
Hmm.
2017, this one over partition in this case. Because they start submission to give them the. What are subject to this outcome or subject to be made. This is how they want to enter the and delay them. The 8.15. The required person is not capable of teaching the code. All the remote point is sickness or presence of the required person is not very high. What we are trying to look at
ಅಲ್ಲಿಂದ ಹೆಂಗ್ ಮಾಡೋದು? ಲ್ಯಾಪ್ಟಾಪ್ ಇರುತ್ತೆ ಬಟ್ ದೆನ್ yes, is that acceptable to you? ಅಲ್ಲ ಆಯ್ತು, ಇವಾಗ ಅವ್ರ ಮನೆಯಲ್ಲೇ ಮಾಡ್ತಾರಂತೆ, ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. Let him complete. ಕೊಡಿ ಅದೇನು ಕೊಡಿ.
And they go for person what all did not give an answer. That's it. And my younger friend says that there was one answer. We got filed by money, three documents. Also, they don't There's 38 fundamental values in that. One person answers they are going to work regarding the orders. But 4 pages of message that they have to answer. I have done the application visa. I'm writing your public. The very same witness according to them they are sick. And the very same witness appeared before this court giving the orders of conduct. The conduct the personality in the order. It was written in 2020. Before COVID. After COVID, jabs were taken. People were taking the third jab. Because of co-monetization. Not even the third jab. And suddenly he said that all these things, because they wanted to record the video recorders at the presence of the council. And he was cross-examined by all the councils. Because here for the extent is
Yes. You will allow this application. You will allow the application, let them conduct the cross-examination on any date suitable. You suggest what date is convenient. No. Until the cross-examination is over. That cannot happen. First, let the cross-examination get over. This is a key witness. If something happens to him, then the whole evidence will be gone. So better you please suggest the convenient date. Whatever date is convenient to you, please suggest after obtaining consent or whatever from the council. We'll direct the trial court to monitor and regulate the time for each person. Yes. Correct. The law, each lawyer will have a different way of cross-examination. Could be. Correct. It could be, but to get the truth, the lawyer will have different ways. You swim differently, I swim differently. Everybody is in the same pool. Everybody swims the same way. You have to beat your legs, you have to beat your. But the strokes could be different. Everybody has the same brush, same paint. Strokes are different. What comes out is different. Where's the plane? Plane at page 10. Defendant number 1 sons.
And defendant number 2 is the claimant. And defendant number 5 is the daughter, is practicing advocate at America. Yes. And 1 to 5 also, right, on the partition. And the contesting defendants are 6, 7, 9, and main contesting, they are the family member. And also 11, 12.
6, 7.
6, 7, 9, 11, 12, 13. See, the other parties,
Who are these persons?
they are with one is K. Narayan Reddy's children. Wife, Chadama is the wife of Narayan Reddy's children.
How is Narayan Reddy related to this?
Narayan Reddy is the brother of Lakshmi Reddy, number 2, and another of K. Reddy.
Narayan Reddy.
Narayan Reddy is the elder brother, but defendant number 1 and 2. 24 brothers, Narayan Reddy, Venkatram Reddy, and Chadama is the wife of Narayan Reddy, Vijayalakshmi is the daughter, and 9th defendant is the son of Narayan Reddy. 7th defendant is Srinivas Reddy, who is no more, succeeded by 11, 12, and 13. So they are the family members. They are contesting this one.
Perfect. Yes. What is this contention of the defendants?
The defendant's contention is Argon 1582.
1582.
82. There is a severance of giant family. Since defendant number 1 is employed in the American bank as a manager, defendant number 2 is settled as a doctor in America, and they don't want the properties. Therefore, they relinquish their rights and execute a settlement deed because it is not released. And in 82, the property was not having any value. After formation of the ring road, the property has become value. Then it was given from January 2025. Apartments are constructed in new properties. That's in survey number 68 and 70.
New year again.
And the random third defendant.
7th defendant.
Third defendant.
You
I
are-
got 2 acres in the survey number 68, and that is also part of land development. We have not defended number 2. So when the apartments have come up, the first defendant asked for one apartment, for which Mr. Mohan, his son, has given one apartment. And thereafterwards, the second defendant also asked for 4 apartments because this is very important. There the litigation started. When the litigation started, the first defendant who admits that the signature belongs to me, to partition, who is the brother. There is no dispute. And Lakshmi Reddy also signs. He says, I was not having the passport, therefore I have not signed. When you have signed, we are sending the document to the America, and it comes to the actual also.
Document America document ಇರ್ಬೇಕಲ್ಲ.
ಅಲ್ಲ ಸಿಗ್ನೇಚರ್ ಮಾಡಿದ್ದಾರೆ, ಸಿಗ್ನೇಚರ್ ಅಲ್ಲ, ನಾನು ಸಿಗ್ನೇಚರ್ ಮಾಡಿದ್ದನ್ನ ಯಾವಾಗ 2017 ನಲ್ಲಿ 16 ಅಲ್ಲಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿದ್ದಾರೆ, 2017 ನಲ್ಲಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿ.
So effectively, everybody is hinging on to this document 1582. Everybody is claiming under this document. So why should everybody be given an
No, that's not precisely. See, the interest of each party is different because in survey number 68, I got right, my brother and my mother.
It's only regarding the execution of this document. Whether he has signed, he has not signed. ಅಷ್ಟಕ್ಕೆ ತಾನೆ.
And after the electric contribution, the way which we wanted to ask cannot be received.
ಕರೆಕ್ಟ್ ಮಾಡಬೇಡಿ ಅಂತ ನಾನು ಹೇಳ್ತಿಲ್ಲ, ಮಾಡಬೇಡಿ ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ. If Lakshmi Reddy is one of the signatories to this agreement or whatever partition, then it is only that fact that has to be proved from this Lakshmi Reddy, nothing else.
The other properties which he acquired, he is not guided to partition.
ಅದ್ರಲ್ಲಿ ಬೇರೆ ಏನೋ ಮಾಡ್ಕೊಳ್ಳಿ.
ಅದನ್ನ ಯಾಕೆ ಅಂತಂದ್ರೆ supplement only that document because the property value has been because of the apartment. All other properties if it is given guide for a partition, then I will say Yes, he's right.
Therefore, Lakshmaya Reddy, if he has got other properties which is not included, only one person can put that question. ABCD property ನಿಮ್ಮೆಸಲ್ ಇತ್ತು ಅದನ್ನ partition ಹಾಕಿಲ್ಲ. Then 1582 document, prove it. One of you, why should everybody ask the same question to the same witness?
No, that's not. And as my lord said, the way of class examination by one concept to other concept, those 7 point comes to 1.5. Alright. Therefore, I am not provided with opportunity at all.
The difference is based on green level and
9,
11 and 13.
9, 11.
It's a bit different. Because that is why I said.
Whom do you represent? 9?
Because 9, which I would be from the branch of Srinivas Reddy for D11. D9 will not have Mohan Ram, who is represented by. So we all have a different this issue. This we didn't know that. But class, what has happened now? Certain properties should certain properties of 9. In 1971, not prior to this, 1971, where the owner of the city was, then itself not certain properties that is allocated in favor of the branch of Srinivas Reddy. No, I don't know. But apart from that, the branch of Srinivas Reddy.
That you can cross-examine plaintiff. So you can cross-examine the plaintiff.
Yes. Now the place across the we do not see as agreed to all this. No, what happened post 1982 and prior to filing of this. At least there are no limitations which not there not. I am saying what are the limitations?
He is not bound by it. He is not bound by it.
These are natural.
I have to let the trial court decide about which is a provision under which the trial court can regulate the time. Order 18. Time regulate ಮಾಡೋದು ಯಾವುದು? Order 18 rule 1. 15. Order 15 ಇರಬೇಕಲ್ಲ? There is a provision which provides for regulating the time. Order 15. No. CPC provides a time fix ಮಾಡೋದಕ್ಕೆ ಯಾವುದು? Summoning and attendance of witnesses. Yes, Mr. Rajesh, there is a provision which permits the time court to fix time. Yeah. No. Court can fix time. Sorry. No, you please come to order 17. 3D. Order 17 to 3D. The court shall fix such time limits for the oral arguments by of the parties in the case as it thinks fit. ಈ ತರ ಎವಿಡೆನ್ಸ್ ಏನಾದ್ರು ಇದೆಯಾ? 17 rule 3 2D ತರ.
it is the destination of the trial court, which it should do.
Order 18 ಅಲ್ಲಿ ಏನಿದೆ? Right, but can the court restrict the time for purposes of recording evidence? ಬರುತ್ತಲ್ಲ. Order 18. Order 18 rule 2D ಗೆ ಬನ್ನಿ. Oral arguments ಅಂತಿದೆ. ಇದನ್ನ ಕೇಳ್ತೀವಿ ಎವಿಡೆನ್ಸ್ ರೆಕಾರ್ಡ್ ಮಾಡೋದಕ್ಕೇನ ಇದೆಯಾ ಅಂತ. Anyway, we'll permit the trial court to fix time. You are allowing your petitions, Mr. Mister, you should also look at the difficulty of that man sitting there. He has to be awake throughout the night. Please also understand that man's difficulty. 80. No. What will be the time? 11 and the not at 12 o'clock. That is the time when that man gets sleep. They get sleep only at 12 o'clock. Not 9:30 also. It will be only after he gets up. So even if you say about 4 o'clock and the 4 o'clock, Chicago is to there too. Please check out. Americally, there are two different timelines. Check Chicago check. You can check it on the mobile. Note check 3 o'clock. What is the standard time now? 3:36 a.m. What is the difference?
So we have a difference of almost 14 hours.
3:43 ಅಂತ ಹೇಳ್ತಿದಾರಲ್ಲ.
So ideal members is not only we have it around 4 o'clock in the evening, 4:30 in the evening. Yeah.
14 hours. 3:30 ಅಂದ್ರೆ ಎಷ್ಟಾಗುತ್ತಲ್ಲ? ಅಲ್ಲ ಅಲ್ಲಿ ಶಿಕಾಗ್ ಬರ್ಬೇಕಲ್ಲ ಅವರು. 2:30. 11ರಿಂದ it is very no. How can a witness age 88 years sit up at in the night, dead of the night at 12 o'clock? Correct, you are very inhuman. Lawyers are very inhuman that way. Correct. So therefore, how can the court fix the time for a man to be awake throughout the night? We'll fix it only at 4 o'clock US time, Chicago time. 4 o'clock US start Indian time. ಅದಕ್ಕೆ ಹೇಳಿ ಎಷ್ಟೊತ್ತು? 4 o'clock, from 4 o'clock to 6 o'clock. 4 o'clock Indian Standard Time. Yes, Mr. Rajesh. 4 o'clock ಎಷ್ಟೊತ್ತಾಗುತ್ತೆ? What will be the time there? So that is better.
One submission in my position. We are okay with the advocate that is this person 124 of my petition or small demands. So is there, we don't have any objection. With respect to that man, we have serious objections and cross-examination mandatory now.
No, you have a golden opportunity. You have a golden opportunity. Yeah. Yeah, they'll be happy to bear because all these people are sitting on a pile of real estate. So they should be happy to bear the expenses. But if visa sigvakala.
If we have an apartment, the meeting there on.
You need not depend on your client. God has given you enough. You can pull US to India. Problem is you're not spending. Yes. Therefore, all the petitions are allowed. Consequently, BW1, consequently, the impugned orders passed to the trial court is set aside. BW1 is required to face further cross-examination. The trial court is directed to fix an appropriate date for cross-examination after obtaining confirmation from the Indian Council, from the Indian Consulate in Chicago. To stop the trial court is directed to record the evidence PW1 from 4 p.m. IST Indian Standard Time till 6 p.m. Indian Standard Time on every date, on every day till he is fully cross-examined. The trial court shall record the demeanor of the witness as well as the demeanor of the counsel who is assisting the witness at the remote point. If the court comes to the conclusion that the counsel is prompting or assisting the witness in answering the question, the court shall be entitled to direct the advocate to withdraw from the place. To stop. It shall also direct the counsel not to wear any mask or cover on his face. Full stop. ಯಾವತ್ತಿದೆ next date? Full stop. The ಪಾಸ್ವರ್ಡ್ ಆಗಿದೆಯಾ? ಯಾವತ್ತು next date? The trial court is directed to expeditiously record the evidence of BW1. Full stop. It shall also regulate the time that may be granted to each of the parties in the suit who are litigating. Yes. Yaar tappidu. Who is at fault? Who is at fault? You are not at fault. They are not at fault. Who is it? Yes. Court can fix such a fee. Time, huh? Trial court or madly. Let the trial court pass an order. 2 hours ಕೊಟ್ಟಿದೆ. Let the trial court take a call. See, the trial court knows the facts. Let the trial court decide. In charge of the court alone. Yes. Who's the registrar there? Huh? Correct. ಇಲ್ಲೇ ಮಾಡಬಹುದಾಗಿದೆ. We could have recorded the evidence here itself. ಅಲ್ಲಿ ಯಾರು ರಿಜಿಸ್ಟರ್ ಇದ್ರು ಹೇಳಿ. If he is free, we'll ask him to record the. ಇಲ್ಲಿ ಯಾರಿದ್ದಾರೆ? ಲೀವ್ ರಿಸರ್ವ್ ಯಾರಿದ್ದಾರೆ? ಯಾರು? ಆಯ್ತು, ಇಲ್ಲಿ ಯಾರು ಲೀವ್ ರಿಸರ್ವ್ ಚೆಕ್ ಮಾಡ್ತೀನಿ ತಾಳಿ. If there is any leave reserve district judges here, you'll see. You can't disturb the registrars here with additional work. There are leave reserve, we'll try to see whether the evidence could be recorded on a day-to-day basis. That will be the order. I'll find out if there's any leave. Check murder. No, that is not. That you arrange. Come one day in advance. Come one day in advance. One day in advance to Chicago. Stay there. Enjoy the weather. Correct, Mr. If they have if they have so much apprehension in you coming to the consulate general office, and if an advocate also accompanies that witness, Ram Prasad is in Bangalore. Please come back. ತಿರ್ಗಾ ಹೋಗ್ತಾರೆ ಮತ್ತೆ ಹೋಗ್ತಾರೆ. All that you have to do is buy a ticket. ತಿರ್ಗಾ ಹೋಗ್ತಾರೆ. Sir, going to US is not an easy thing. First of all, visa sigbeku. Have you ever experienced getting a visa from US consul?
But then, one is a mask, second is intervention quite often. And if it doing it quite often, it has been recorded also. Then there will be
No, again, one more opportunity. Golden opportunity. Okay. A law minister ಮಾಡ್ತಾರೆ ಅಂತ ಭಯಾನ ಕರ್ಕೊಂಡು ಹೋಗಿ. Yes, I'll let you know. If there's any leave reserve, we'll direct the evidence to be recorded here. If there's any leave reserve here. First, the evidence record agudli. Mr. Rajesh will let the evidence come. Let us record the evidence. You are the one person who can speak about this document. So if we lose your evidence, then it's gone for perpetuity. Your application hakbekalva. You should file an application saying that please record my evidence. I am about to die. Provision ಇದೆಯಲ್ಲ. So evidence of the plaintiff is not yet recorded. No leave reserve. So let the trial court do it. Well, let the trial court regulate it. Let the trial court regulate. The petitions are disposed of. The petitions are all disposed. Yes. Costa. Cost for what? Yes. It is nobody's fault. It is nobody's fault. Next. The plaintiff can ಬೇಕಾಗಿಲ್ವಲ್ಲ. Office objections ಇದರಲ್ಲೆಲ್ಲನೂ 34 ಅಲ್ಲಿ the note below the cost title is accepted. 34.1 ಅಲ್ಲಿ notice to respondents 2 to 28 is dispensed. Since the contesting respondent is only the respondent number 1. Full stop. 34.2 ನಲ್ಲಿ Lokesh DC. Notice to respondent 2 to 28 is dispensed in C number 34.2. Office objections are overruled. 34.3 office objections are overruled. Notice to respondent 2 to 28 is dispensed. The order sheet will work. Next. So that is a cost that you pay for not coming to India. What can be done? It is a cost you paid for not coming to India. At the end, so I have given the liberty to the trial court to decide the demeanor or the conduct and to regulate. Everything I have given. Yeah. The other one says the trial court shall ensure that the questions put to DW1 is not repeated by the other counsel. Yes, you had something to say. No, ಹೇಳ್ಬಿಡಿ. Page 10, huh?
Then comes existing. There are two roles. So according to them also, this is given by the land owners. And according to them also, there is a road, there is another, then our property.
No. This property comes in survey number 100. This Nala comes in 100.
For the moment you have to try all I'm saying is, as for our case and our case and the Nala comes from the western side of our property. Our property was measured, there is no improvement in our property. So therefore, admitting him should not from outside the property. Even according to them, there is therefore their side does not come immediately. There is a road in between their side and our property and the Nala. The application of the runner for the impleading application for is the way we start to know in the buffer now is going to be affected. I have two submissions to take on this aspect. One is this is a man-made. The media submitted it does not apply to this aspect of the matter. Because it is being done by the media and it's not a non-actor. The second aspect, it is 30 feet from assuming for I showed a feet from yes, assuming the worst in your side property go on the portion of the compound wall.
No, but the problem is your property ends where 92/2 begins. So, Alala, your property ends. The spot inspection, what is revealed is your property and 92/2, there is no gap. So, if there's no gap, where did the Nala go?
As of today, 92 is not measured. What is their information? I don't want to say they have report. I don't want to go into that because I am assuming. Because assuming it is my property, assuming for a moment it can be at the worst for the compound wall, even according to their knowledge, only first can be only on the compound wall after the road and on my compound. It's not that I don't want to go into this. My land was measured. It's not a issue for them what I okay. The word based on their own document, their own not a compound wall. As for the media and the panel, they start becoming the place. This their layout plan of the revenue department, that also still comes on the investment. Let it be as well without going into as a appeal also to the election. Therefore, I don't want to go into the. Therefore, Procedural does not apply. Most data gets me also has to be confirmed for
30 feet road idea.
325 times the court.
Let us appear the appointment.
ಅಲ್ಲಲ್ಲ ಈ ಪ್ಲಾನ್ ಪ್ರಕಾರ ಇದು 30 feet road. Why I am trying to do ಅಲ್ಲ ಈ 30 feet road ಅಲ್ಲ Mr. Please listen to me. Yeah, 30 ಅಡಿ ರಸ್ತೆ ಇದ್ರೆ without causing any damage to anybody, can this stormwater drain be re-established? Say 45 feet is the 15 meters alva. Site number 333, no?
This site has been purchased. They can't hold it in that it is modified plan. Then it is also produced, the document page 40, page 4. So therefore, all of them are purchased as per this plan. Page 4 may be changed in page 4.
Where PNT layout here? Illiದೆ. JP Nagar ಅಂತಿದೆ ಇದನ್ನು. JP Nagar. From Rakesh.
Survey number 82.2 is post become employee. So can you see the schedule? Page 9. Schedule is correct. Let him file the application, not the owner.
There's some advocate called Mr. H.N. Srinivas. Hope it's not your friend, a colleague. ಅದಕ್ಕೆ ಕೇಳಿದ್ರು. Is anything else? Yes, anything else?
Next to this property, I will the plan with.
Next to this stormwater drain, there's houses, is it?
I have read the photograph. Our property, that I know.
ನೀವೆಂತ ಮನೆ ಡ್ರೈನ್ ಪಕ್ಕ ಮನೆ ಕಟ್ಕೊಂಡ್ರಿ? ನೀವೆಂಗೆ ಡ್ರೈನ್ ಪಕ್ಕ ಮನೆ ಕಟ್ಕೊಂಡ್ರಿ? 15
Not finding fault. Whatever you think we should. Whatever you not produced a plan. Last point, because 1992 is the conversion. 1994 conversion also shows this is global property. Conversion for the on the other side.
Yes.
I should really put it with 82 and this also or it doesn't mean our property. Comes on the order as per we purchase the property here 2000. So then so therefore model we went all on the so we have done document which were on record. And our division is also
ಇದ್ರದ್ದು ನಿಮ್ದು ಇದೆಯಾ CDP ಫೈಂಡಿಂಗ್ಸ್ ಎಲ್ಲ ಇರ್ಬೇಕಲ್ಲ ಈ ಪರ್ಟಿಕ್ಯುಲರ್ ಲೋಕಲ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಅಲ್ಲಿ ಇರ್ಬೇಕಲ್ವಾ ಅಲ್ಲಲ್ಲ CDP ಫೈನಲೈಸ್ ಮಾಡಕ್ ಮುಂಚೆ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಾಲ್ ಫಾರ್ ಮಾಡ್ತಾರಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಾಲ್ ಫಾರ್ ಮಾಡ್ತಾರೆ you have the report of this particular survey number.
Like finding the CDP, they show it in the area of our property. What is the material that consideration of forming?
Yes. You have a copy of that. Please secure that. A particular survey number though, objections, CDP objections. Yes. More but you have to produce. You have to produce all the records, particularly of this survey number 100/4, 100/4, 102/2, 100/2. Yes, survey number 100/4 and 102. 102 of Rachanalli. I want all the records subsequent to the filing of objections and thereafter. In the CDP. ಮತ್ತೆ ಮನೆ ದಾರಿಯಲ್ಲಿ ಇರ್ತದೆ
There was a TV that was housed to be converted as a site, and they want to shift the load to the place where there is no road at all. Realizing their land, it was meant for the road, but they are interested in this. If there is any modified road plan, they can bring it. There is only plan available to do this. That's even if we
The 92/2 ರಿಲೀಸ್ ಆಗಿದೆಯಾ ಇಲ್ವಾ? Who is the owner of 92/2? Find out who is the notification errors. Notification, I don't know whether I have notification errors. Notification ಆಮೇಲೆ ನಾನೇನೋ ಅಪೀರ್ ಆಗ್ಬಿಟ್ಟಿದ್ದೆ ನೋಡ್ಬಿಟ್ಟಿದ್ದೆ ಅರ್ಥ ಹೊತ್ತಿನಲ್ಲಿ
Lala, if I have appeared for survey number 90, I don't remember. I could have appeared, I'm not sure. ಅದಕ್ಕೆ ಹೆಸರು ಹೇಳಿದ್ರೆ I can try to recollect. ಅಲ್ಲ ನೋಟಿಫಿಕೇಶನ್ ಯಾವ ಹೆಸರಿದೆ? ನೋಟಿಫಿಕೇಶನ್ ಆರ್ಲೋ. ಅಷ್ಟೇನಾ? Anything else? Please also find it from the notification. I think you must be having a copy.
I'll verify the information.
ಅಲ್ಲ otherwise I have to ಅಲ್ಲ ಆಯ್ತು
Second thing, I probably want and there is a road. Third thing, concealing and private activity, I will take it in my property. These are the three things. Not going into anything affecting you.
knowledge for dictating or anything else. ಬೇರೆ ಯಾರೇನು ಹೇಳೋದಿದ್ರೆ ಹೇಳ್ಬಿಡಿ ಈಗಲೇ. No further submissions. No, it's all. All of the matters at 2:30. What warrant? Arrest warrant. Arrest warrant. ಕುಡಿ ಯಾವತ್ತಿದೆ ಮೆಮೊ ಕೊಡಿ ಯಾವತ್ತಿದೆ ಕುಡಿ ತಗೊಳ್ಳಿ ನಾಳೆಗೆ ನಾಡಿದಿಂದ ನಾಳೆ ಮೂವ್ ಮಾಡಿ ನಾಡಿದ ನಾಳೆ ಮೂವ್ ಮಾಡಿ
Sir, court officer. Sir, court officer. Sir, court officer. Hello. Hello.
ಬರ್ತಾರೆ ಮೇಡಮ್ ಒಂದ್ ನಿಮಿಷ.
ಆಡಿಬಲ್ ಇದ್ದೀನಾ ನಾನು?
ಹಾ ಕೇಳಿಸ್ತಿದೆ ಮೇಡಮ್.
Okay, thank you.
ಹಲೋ. ಹಾ
What up, sir?
Ready, sir.
ಸರ್ ಫೋಟೋ ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 22 ಪಾಸ್ ಓವರ್ ಆಗಿದೆಯಲ್ಲ, ಏನು ಅವ್ರು ಬಂದಿಲ್ಲ ಅಂತನಾ ಅಥವಾ ನಾವಿಲ್ಲ ಅಂತ?
ಪಾಸ್ ಓವರ್ ಆಗಿದೆ. ಏನ್ ಅವ್ರು ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡ್ಬೇಕು?
ಅದಕ್ಕೋಸ್ಕರನಾ? ಥ್ಯಾಂಕ್ ಯು.
ಪಾಸ್ ಓವರ್ ಆಗಿದೆ ಒಟ್ಟಿನಲ್ಲಿ.
ಹಾ ಸರಿ ಸರಿ.
ಮುಗಿಸಿ ಬಿಡ್ತೀರಾ ಕರೆಕ್ಟು, ಬಟ್ ಇವತ್ತೇ ಮುಗಿಸಿದ್ರೆ ಆಗಿರುತ್ತಲ್ಲ. Is it difficult for you to argue today? ಮುಗಿಸ್ಕೊಂಬನ್ನಿ. Last chance, it's on. Request of the land council for petition responding to list on. ಕರ್ಬಿಡಿ ಪಾಸ್ಪೋರ್ಟ್
matter.
ಮಾಡಿದಾರ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ petitioner carried
Petitioner in this matter.
office to check and verify.
Lord, serial number 32, my lord, I appear for the petitioner.
The number? ಯಾವ ನೆಕ್ಸ್ಟ್ ಯಾವ? ಮೋಹನ್ ಚಂದ್ರ ಪಿ. ಹೇಳಿ ಏನಂತ ಹೇಳಿ ಈಗ ಕಟ್ಟಿದಾರ ನೋಟಿಸ್ ಕಟ್ಟಿದಾರ ಎಸ್ ನೆಕ್ಸ್ಟ್ ಸರ್ Who are they? What are they claiming?
They are claiming that item number 1 of the CCP property belongs to them. Yes, they are necessary party in the property. On the other reason and the right for development, as a visitor, the proposal respondent and right, but it is a report to common. They must follow by this board and the matter was accepted and demanded by the Listening assignment right for them. One out of completed project, you can accept not finding property for proposal.
So who are these proposed respondents? Strangers, how are they claiming? What is their interest as per their? Where's the application? Please read the affidavit. Who is this Naranappa? Naranappa is the husband of Sonnamma. Sonnamma's wife, the husband's name is late N.G. Munireddy. Who is the plaintiff and defendant relative? If Naranappa is? Naranappa, son of Ramaya, had sold the said property in favor of Naranappa, son of Venkatappa of Nidagurti village. They said Naranappa, who is my brother and father-in-law of the applicants 1 to 3 herein. So if there is a sale deed in their name, Please come to this. Said Naranappa sold the said property in favor of Naranappa, son of Venkatappa. So therefore, how are these applicants related to Naranappa? Page number? So that is a fact that is to be gone into. That is a fact that is to be gone into. Then again I am saying this is a fact that has to be gone into. Now the applicants claim, Venkat Lakshmama claims that she is the daughter of Venkatappa. She claims to be the daughter. Sir, should we decide the case at the trial stage itself? Mr. Should the trial court decide this issue even without evidence? Whether is the daughter of Naranappa, Venkatappa, or whether she is not the daughter of Venkatappa? Can it be decided by way of an interlocutory application? Purple. The plaintiff in OS number 163 of 2017 on the file of the so-and-so court has filed this petition agreed by the order dated 6/7/2022 by which an application filed by the proposed defendants to be impleaded was allowed. Next para. The suit in OS numbers 163 of 2017 was filed for partition and separate possession of the plaintiff's share in the suit share property. Full stop. The plaintiff claimed that the suit property was owned and possessed by her grandfather How did your mother get this property? Purchased by, was owned and possessed by her father. And after his death, the kata of the suit property was changed to the name of his wife, Srimati Sonnamma. Full stop. She claimed that the defendants denied. The defendants did not consider her request for partition separate possession of her share in the suit property, which forced her to file the present suit for partition. Next para. During the pendency of the suit, an application was filed by the proposed defendants and order 1 rule 10 bracket 2 of CPC to come on record as defendants in the suit. Full stop. They claimed in the affidavit accompanying the application that the suit property was purchased by Venkatappa, son of Naranappa, son of Venkatappa, in terms of a sale deed dated 26/9/1960. Said Naranappa, son of Venkatappa, was her brother, and the father-in-law of the proposed defendants five, 6, and 7. Full stop. She contended that the plaintiffs are blank strangers to the suit schedule property, to item number 5 of the plain schedule properties, and were not concerned to their family in any way. Full stop. They claimed that in the event of a decree being granted in the suit, they would be put to untold hardship, and a flog on their title would result. Therefore, they prayed the court to consider the application to come on record as proposed defendants. The trial court initially rejected the application, which was challenged before this court in WP number 2306 of 2020. This court, in terms of the order dated 16/3/2022, allowed the writ petition and directed reconsideration of the application. The trial court, after reconsidering the application, allowed the application in terms of the order dated 6/7/2022. Being agreed with the same, the present petition is filed. Next, the learned counsel for the plaintiff / petitioner submitted that the applicants are strangers to the suit properties, and therefore they are not intended to come on record. He contended that the defendant number 1 was the only daughter of Muniappa to Venkappa, and there were nobody else who were interested in the suit properties, and therefore, proposed defendants were absolute strangers. He further submitted that, except the self-serving statement that the suit item number 5 was purchased by Naranappa, son of Venkatappa, no material document was placed on record in that regard. So I consider submission made by the learned counsel for the parties. The proposed defendants categorically claimed that suit item number 5, namely the land in survey number 113/3 block, measuring 4 acres, situated at Nidugurki village, Chintamani Taluk, was purchased by Naranappa, son of Venkatappa, in the year 1960. We have also placed on record a copy of the sale deed dated 26/9/1960, which discloses that the land bearing survey number 113/3 block, measuring 4 acres, situated at Nidugurki village, was sold by Naranappa, R. Naranappa in favor of Nagappa, son of Nagamappa. Full stop. In that way of the matter, the proposed respondents were interested in the outcome of the suit, without whose presence, outcome of the suit and any order that may be passed in their absence would definitely eclipse their title to the suit schedule property. Full stop. In that way of the matter, comma, the trial court was justified in impleading allowing the application of the proposed defendants to come on record. There is no error warranting interference by this court. Hence, this petition is dismissed. Correct. Your 60 sales ಇದೆಯಲ್ಲ. Correct. To 60 sales ಇದೆಯಲ್ಲ. We do not know who is this Venkappa. Please come to the sale deed. Page 31. Naranappana maga. Idu Nagammapana maga. Naranappa. Mr. That's a matter for evidence. ನಮ್ಮಲ್ಲಿ ನಾಗಮಪ್ಪ ಅಂತ ಹೇಳಿದೆ ನೋಡಿ, ನಾಗಮಪ್ಪ ಅಲ್ಲ, ವೆಂಕಟಪ್ಪನ ಮಗ ನಾರಾಯಣಪ್ಪ. So that's it. Even the G tree is a subject matter of trial. Yaar is application active. Who has filed the G tree? Nagaratama. But then which is the, what is this G tree produced by the page number 28? At the page number 30, so therefore, what is right? What is right? More G tree there. We can't decide it by the stage of interim application. Yes, Ravi HK. Yes, Ravi HK.
Lord, I appear for the petitioner in this matter. My Lord, the petitioner has impugned the order wide annexure D, the order on the application wide annexure D, my Lord. An application was filed by the respondents 1 and 2, seeking to implead themselves as plaintiff numbers 2 and 3 in the suit bearing number OS number 7/2016, my Lord. Lord, earlier, the respondent number 3 herein had filed a suit for declaration of title in respect of the suit schedule property on the basis of a unregistered will executed by her father, my Lord. And the proposed plaintiff number 2 had given evidence on behalf of the plaintiff in support of the will. When the matter stood at the stage of cross-examination, my Lord, this application came to be filed, seeking impleadment as co-plaintiffs in the suit.
This is suit for what?
Suit for declaration on the basis of unregistered will, my Lord. It is the case of the plaintiff that she is the owner of the suit schedule property by virtue of an unregistered will executed by her father, namely SB Kent. During the pendency of the suit, my Lord,
who are the defendants?
My Lord, the defendant number one, that is the petitioner herein, my lord, is the subsequent owner of the property. That is, there was earlier an oral partition in the family. By virtue of oral partition, the defendant number one wife got the property, and later there was a partition between defendant number one and his wife. And by virtue of the partition,
From whom did he purchase? Christopher Mest.
my lord, he has not purchased the property, my lord.
How did he get it?
He got it through his wife, my lord, under a partition deed.
How did Meera Kent get it?
By virtue of an oral partition, my lord.
Oral partition between whom?
Oral partition between the plaintiff, Meera Kent, and the other siblings, my lord, of SB Kent.
Who are these applicants now?
The applicant number one is the mother, my lord. The applicant number two is the sister of plaintiff.
So shouldn't that will be adjudicated upon?
Yes, my lord, the will certainly needs to be adjudicated upon. However, these proposed plaintiffs want to get impleaded by contending that if in case the will is not established, they are entitled for partition of the suit schedule property.
Yes, obvious.
Yes, my lord. But in a suit for declaration by virtue of a will, my lord, the plaintiff will have to establish her title on the basis of the will. However, the proposed plaintiffs 2 and 3 cannot seek a partition because that changes the very nature of the suit, my lord.
Yes.
Therefore,
we permit them to come on record as defendants.
that is not their application, my lord. Their application is they
We
want to
permit them to come on record as defendants.
and further, my lord, they intend to claim relief of partition, my lord, in the suit for declaration, my lord.
If the will is not proved, will they not get a share?
No, they have to initiate a separate proceedings because the pleadings are entirely different, my lord.
Not necessary.
Pleadings and prayers are different, my lord.
They can raise a counterclaim now in the suit.
My lord, there is no such prayer as such sort by proposed plaintiff, my lord. Therefore, as per the application, my lord, the same is not maintainable.
What is the stage of the suit?
My lord, the cross-examination of the plaintiff witnesses have been completed, my lord. Now it is for defendants' evidence.
Can you permit them to come as on record as defendants?
My lord, let them make a separate application, my lord. We'll get an opportunity to oppose it, my lord, not by virtue of these applications.
Notice, in addition, the learned counsel for the petition is directed to serve the learned counsel who represented the respondents before the trial court. List on date 30th September.
My lord, till then, my lord, let there be an order of.
Sorry, no. Just next.
My lord, if they are impleaded, my lord, as plaintiffs, my lord, the suit will go on.
Let them go. Yes, go on. You can strike out the parties. One rule.
My lord, the order may be stayed, my lord. The suit may go on, my lord, but the order may kindly be stayed.
Well, let it. Please serve the notice. Let us. Could we fill the next date of hearing? The impugned order is stayed. However, the trial in the suit shall go on. The list on date 30th.
One submission, my lord. So far as the trial, my lord, in another application which is questioned before this honorable court, the proceedings have been stayed, my lord. So far as trial.
Why do you ask? Then why you want?
So far as this order is concerned.
Correct. If the entire thing is stayed in another case, why do you want two stay, double stay, double injury?
So far as this order is concerned, my lord, only so far as.
The entire proceedings are stayed, Mr.
My lord,
you can't even put a pen on the order sheet. You can't even lay the pen on the order sheet.
Yes, my lord.
But stay what I figure that. This next. Please be seated. We'll call you. ಈಗ ಬನ್ನಿ ಒಂದು ಎಲೆಕ್ಷನ್ ಮಾಡಬೇಕು. You know the dispute between the parties. So what you have to do is you have to first prepare a voter list or electoral roll. So for that, you have to give them 10 days time. All the members, whoever want to come and enroll, we will ask all the members to come and enroll with you. They'll have to come with a slip showing the payment of the monthly subscription and 500 rupees. 500 rupees. Everybody, whoever comes to you, they should come with a slip saying that we have paid the entire arrears, there is no entire due, and that there are no arrears. Based upon that, you will prepare a voter list. Voter list, Madi, you can appoint somebody as an election officer and let him conduct the election. The dispute is only in respect of about 700, 800 workers, because 2,500 is already there. 2350 is already there. So all that remains is about 1,000 and odd members.
Already paid the fees and we are eligible as voters. And because some of the amounts are directly to the bank, so I say it's a bank of whatever the bank is there. Those documents they are taken to those. And we are not saying that whatever I actually my other obviously responsible, I say that over has taken the document. And those who are not taking care will be retired.
Or do you want time to find out how much? No, no.
Yeah, election has to be over.
Not a month's time.
First one is there are no stoppages of everybody have paid. This is continuously.
Takeoff facility, what happens? The employer deducts the money, gives it to the union. So it is all the money of the employees. This was not. I am trying to find out a way out. This is a money, or is a part of the subscription fee is deducted from the salary of the employees and given to the union. Correct? Alva. If the members want to enroll, whoever again a default if they fail to pay, let them pay and become members. What is the difficulty?
Is discontinued for a period of more than 3 months.
Sir, we are ignoring that.
Everybody has to pay
So what's your?
That record has been submitted twice the union to the authority as well as because if any objection is there, you can find it on the register.
No objection. It's only the register. 1 point. New objection file ಮಾಡೋದು not. ಕೊಟ್ಟಿದ್ರೆ recover ಮಾಡೋಣ ಆಮೇಲೆ, that's a different thing. ಕೊಟ್ಟಿದ್ರೆ recover. What is it you want? You want the union?
Here the entire members from the date of the started of the subscription with the management. Whether everybody has given or not, if they have given, it will be accepted. The proof is bank account. That is from bank.
Can this not be recovered later?
No, recovered or not recovered.
Why? Can this not be recovered later?
They are not. It will be at 3 months.
3 months or 30 months or. ಕಟ್ಟಿದ್ರೆ ವಾಪಸ್ ರಿಕವರ್ ಮಾಡಕ್ಕಾಗಲ್ವಾ?
Interested workers only. I cannot make such submission.
There is no problem, and even admission fee also. Second thing is, some of them, about 50 or 60 people have been dismissed. So those dismissed employees, 33 to be application pending before the tribunal. So that reason is also not to be given. My point is, for example, if 10 years back one was to be dismissed, and the case is pending before the tribunal under 43 to be, they insist as per the enroll, that is by law. They are to be enrolled as in the court of the district. And that is, they will also, they may, give that nomination also to the court. That one also has to be decided. They are not affecting about that one.
A mere dismissal of an employee, if an employee is dismissed, will he cease to become a member of the trade union?
They were dismissed employees pay. Cannot be today.
Right? That is still pending consideration.
Point is, the bylaw should be an employee. Then alone the membership will be given.
Yeah.
No, they are.
Recent member of the union, we assume management has initiated application before order authorities seeking permission, proposal or approval. Applications are still pending to process contest cases.
Now we will simply say, elections will be held in accordance with the bylaws, except the subscription fee, which will be subject to the result of the writ petition. And he will prepare the voters list. He will make sure that whoever is enrolled in the voters list would have paid the entire subscription.
Yes. Correct. Underline something that point will be 33 to it has to be confirmed.
No, it's a bylaws.
Whether it is pending or under the but in one thing, and if we were 10 years back over and his approval application is pending, whether we make a enrolled in it.
He continues to be a member. He continues.
He's arguing just to be member.
Why they don't want us? He dismissed the employee who out of 33 to be application pending. They have amendment pending. We don't know about the result. I expect them to tell my comment. So I know about 33 to be application members. How it could be enrolled in a voters list that they
In bylaws, what is it?
Because I say, stay in tomorrow. It may come tomorrow because we are afraid of
ಆಯ್ತು ಇನ್ನೂ ಒಂದು ಹೇಳೋಣ ಏನು 33 ಟು ಬಿ ಯಾರ್ದು ಇದೆಯೋ ಲೆಟ್ ದೇರ್ ಬಿ ಸಪರೇಟ್ ಒಂದು ಬ್ಯಾಲೆಟ್ ಸಪರೇಟ್ ಇರುತ್ತೆ ಹೇಳೋಣ ಲೆಟ್ ಇಟ್ ಬಿ ಸಪರೇಟೆಡ್ let them prepare a separate list ಅಲ್ಲ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇರುತ್ತೆ but the ballot which they exercise will be kept separate, it will be counted separate.
Before accepting the officer,
Sir, he will notify the list. If you have objection, you file your objection. Adadmale they will whatever. Because now ಹುಡ್ಕೊಂಡು ಹೋಗೋದಿಲ್ಲ. If anybody wants to become a member, he will have to come before the authority.
Okay, later, start date, then you will not become a member. So he has to pay constitution fee and membership fee and enroll as member. Otherwise, it's fine.
The labor officer will not run behind the members. The labor commissioner will not run behind the members. If the members want to be enrolled, they have to go to him, furnish all the details. If they do not give, they will be out of the voters list. Simple. You back idre avara hatra hogi. Give all the details.
At least one the first list will be available with the.
Sir, he will scrutinize all the papers. He will prepare a list. Then he will notify. Notify madamel objections nim time kodtare. Objections file ಮಾಡಿ. ಒಂದೇ date objection ಗೆ no more than one date. ಒಂದು ತಾರೀಕು 15 days notice ಕೊಟ್ಟಿರ್ತಾರೆ. ಅದರೊಳಗೆ ನೀವು objections ಏನು ಹಾಕಿ. Objections ಹಾಕಿದ್ಮೇಲೆ he will notify a final voters list based upon which.
To know whether they have paid 100 rupees and 500 rupees admission.
Yes.
And that one also have to be.
Yes. Please tell us how much time you need. How much time do you need for preparing the voters list? 15 days for inviting applications and 15 days for scrutiny and final. Yes. So therefore the suit will be disposed of before the trial court. Nothing remains.
And the largest things of that the word substantively as far as 33 to be whatever is staying granted, subject to the final decision of the execution.
Yes.
By 127 part 2020.
He is the defendant. And the defendant wants relief.
Let that repetition be there. Suit can be disposed of. In this petition, both of you agree for conduct of elections. So therefore, what is the purpose, fun in keeping that suit pending? ಆಯ್ತು ರಿಪಿಟಿಷನ್ ಪೆಂಡಿಂಗ್ ಸೂಟ್ ಕ್ಲೋಸ್ ಆಗತ್ತಲ್ಲ. ಆಯ್ತು ಎಲೆಕ್ಷನ್ ಆಗ್ಲಿ ಆಮೇಲೆ ಮಾಡೋಣ.
ಜಡ್ಜಿಗೆ ಹಾಕಿ ಹೇಳ್ತೀನಿ.
Yes. Of the election rules.
As per the model election rules.
Election rules. High Court is monitoring this. So therefore, we are appointing you as the 1.1. Please prepare the voters list first. No, we will give you 1 month's time. We give you 1 month's time to prepare the voters list. Thereafter, we will pass further orders as to what should be done. Please be seated. Pursuant to the order dated 7/9/2022, the Assistant Labour Commissioner Division 1, Bangalore 73, has appeared before the court and submits that he would prepare the voters list of the members of the employees union. And thereafter, the election could be conducted in accordance with the election model rules. Full stop. Next para. Yes, I'll come to that. I'll come to that. Though in this writ petition, the challenge is to an order passed by the trial court. Trial court injunction refuse aita.
It was dissolved.
Three one two.
Murthy pakkadalli. Pakkadalli yaru?
Yes, dated 23/12/2021, by which it dissolved an order of ad interim injunction granted, which was confirmed with the appellate court in MA 8 of 2022, the learned senior counsel representing the petitioner, as well as the learned counsel representing the employees union, and the learned senior representing management, all submitted reason that elections could be conducted to the managing committee of the trade union in accordance with the bylaws, as well as in accordance with the election rules, model election rules. Full stop. In that way of the matter, this court considers it appropriate not to disturb the orders passed by the trial court as well as the appellate court in May 8 of 2022. And the OS 289 of 2019 and the MA 8 of 2022, and to oversee the process of conduct of election to the managing committee of the employees union. Full stop. This would put an end to the battle between the warring employees in OS number 289/2021, and pave the way for the functioning of the employees union. Full stop. Next para. The learned counsel for the response 1 to 10 submitted that the membership of the employees union is based on the payment of monthly subscription fee as well as one-time admission fee, and the one-time admission fee of ₹500. Full stop. We submitted that this admission monthly subscription fee of ₹100 was reduced to a sum of ₹25 by the present management, which was challenged in WP number.
By the management, my lord, that is by the assistant labor commissioner. It was challenged, not by the management.
by the Assistant Labor Commissioner, which was challenged for this court in WP number 5127 bar 2022, where 5177, where this court has granted a stay on an order of stay passed by the Labor Commissioner, reducing the monthly subscription fee. He submits that any order that may be passed regarding payment of the subscription fee will be subject to the outcome of the writ petition number so and so. He further submits. Full stop. He further submits that many employees are dismissed from service whose applications under section 33(2)(b) of the Industrial Disputes Act is pending consideration, with respect of which also, the bylaws were amended, which permitted them to continue as members of the employees union, which too is the subject matter of the writ petition in WP number so and so. And therefore, the enrollment of such employees should be separately considered pending disposal of the said writ petition. Full stop. Whatever that you are arguing, that writ petition. Allah. Yes. Full stop. Full stop. In that way of the matter, the Assistant Labor Commissioner who is present before the court is directed to prepare a list of eligible voters in accordance with the bylaws of the employees union. Full stop. While doing so, we shall make sure that the members desiring to enroll should have paid the subscription, monthly subscription, paid the up-to-date monthly subscription at the rate of ₹100 per month, and also the one-time admission fee of ₹500. Full stop. We shall also prepare a separate list of members whose case is under consideration before this court in WP number so and so, and whose application under section 33(2)(b) of the Industrial Disputes Act is pending consideration. Full stop. In order to prepare the voters list, the Assistant Labor Commissioner shall fix a date with we will only fix the date, shall invite, shall entertain the request of members for enrollment commencing from 19 September 2022 for a period of 2 weeks, ending on 6th October 2022. Full stop. We shall thereafter announce, we shall thereafter publish list of eligible voters by 21st October 2022. So any objections to the list of voters shall be filed by 28th October 2022. and the final list of voters will be announced by 7th November 2022. Full stop. Thereafter, the process of election. Thereafter, this court should appoint an officer to conduct the election in accordance with the model election rules by fixing a calendar of events. Stop. In order to supervise the preparation of the electoral roll, list on Yavathu. The 7th quarter, November, Yavathu last quarter. 7th November. List on
October.
14th November. 14th November 2022. 14th November, is it okay? Sir? Put it 7th November finalist. 7th and 14th ಬರುತ್ತಲ್ಲ ನಮ್ಮಂದೆ ಬರೋದು. You have been given adequate time to even file your objections, and even the officer has been given time to consider the objections and prepare a final list. So 14 November 2000, list on 14 November 2022. We'll stop next para. Now that this court has initiated the process of election, the respondents 1 to 10 are directed not to enter into any. Hello, sir. Not to enter into any. Not.
No, we cannot, sir. Because we have so many things to do.
ಸ್ವಲ್ಪ ತಡ್ಕೊಳ್ಳಿ sir. To permit me, I'll complete the dictation. Even before I permit, you are jumping the gun. 1 to 10 are directed not to enter into any agreement with the management which has financial implication.
Working calendar becomes more, sir.
That is not financial implication.
Financial
That
implication.
doesn't have financial.
Yes.
That doesn't have financial.
No financial implication. Day-to-day activities you can still conduct.
Blood, sir. Management and union are required to finalize the working calendar. Now that will
It's
remain
not a
without.
financial. It's not a financial.
Yes, my lord. Your lordship may allow us to
Financial
discuss on that issue.
Financial. Sir, it's a financial. Please don't do it. You can get postponed.
Or policy matters. Your lordship can say any policy involving.
Working calendar is a policy. Working calendar is a policy. Cannot say that.
No. Allowing this to happen will tilt the balance. Don't do that. Watchable photo, you need not take the bike. Obviously. Sir, ಎಲ್ಲ ಮಾಡಿ ಇದಿಲ್ಲ ಅಷ್ಟೇ. No freebies. ಏನು? You can enter into any agreement which does not have financial implication. We will ensure that by evening it will be uploaded. For the day, I will ensure that it is signed and uploaded. Upload ಮಾಡ್ಬಿಡ್ತೀವಿ net ಅಲ್ಲಿ. In his office. In his office. Nowhere else. ಶಿಫ್ಟ್ ಅಂತಾನೆ ಬರೋದು ಎಲ್ಲ ಒಟ್ಟು ಎಲ್ಲ ಒಂದೇ ಸತಿ ಹೋಗಲ್ವಲ್ಲ, ಎಲ್ಲ ಒಂದೇ ಸತಿ ಕೆಲ್ಸಕ್ಕೆ ಹೋಗಲ್ವಲ್ಲ. ಸೊ ಶಿಫ್ಟ್ ಎರಡೇ ಶಿಫ್ಟ್ ತಾನೆ. ಸೊ ಶಿಫ್ಟ್ ಅಲ್ಲಿ ಚೇಂಜ್ ಆಗ್ತಾ ಇರುತ್ತಲ್ವಾ. ಏನ್ ನಾವು ಇದು ಐಡಿ ಆಕ್ಚುಲ್ ಕೇಸ್ ನಡೆಸಿದೆ ಇರ್ಬೋದು. ಅಟ್ಲೀಸ್ಟ್ ಗಾಟ್ ಸಮ್ ಕಾಮನ್ ಸೆನ್ಸ್. ಕೇಳಿದ್ರಲ್ಲ ಶಿಫ್ಟ್ ಬೇಸಿಸ್ ನಲ್ಲಿ ಹೋಗಿ ಕೊಡಿ. Like we've been given 15 days time. Huh? 15 days. Sir, you need not be there. No, don't. ನೀವು ಅವ್ರ ಕೈಗೆ ಕೊಡ್ಬೇಕು ಅಂತ ನಾನು ಹೇಳ್ತಾ ಇಲ್ಲ, ಅವ್ರ ಆಫೀಸ್ ಕೊಡಿ ಸರ್. Why should you do that, sir? ನೀವು ತಗೊಂಡೋಗಿ ಅವ್ರ ಆಫೀಸ್ ಕೊಡಿ ಸಾಕು. You will appoint one person, ನೋಡಲ್ಲಿ ಆಫೀಸರ್ ಯಾರೋ ಒಬ್ರಿಗೆ ಅವ್ರು ಮಾಡ್ತಾರ, ಆಗ that he will do. Thank you for coming. Next, Mr. Chandrasekhar, Pradeep Devi. Pradeep Devi. Yes. Yes, please. What say this application was filed? So 500 meters from the existing poultry farm. So what has happened? So what is
application what might have happened because you guys will not going to see how to terminate or terminate up to whenever good points anything wrong in passing the entry model or locating the entry model. They know they not certainly.
This application was filed after the entry model was confirmed? Before? Ex parte order. Ex parte order.
Sometimes we do not extend. Therefore, this application
Yes. Yes.
After the trial is over, 4 points they need to resolve the real controversy. They are not certainly to have a logical conclusion. The application could be integrated in the appointment, but in this case, not even issues are integrated. We did not cover the proceedings.
So what is your case? You are the defendant in the suit. What is your case? Written statement ಏನಂತ ಹೇಳಿದಿರಾ? What is your case?
That case is not mine. Their case is not the secretary, it's a government man. Their house is not associated. Maybe about 300 meters away from the water.
So therefore he wants to know that. He wants to know the poultry rules and ideal. The environment, the pollution control board has issued some rules. Poultry establishment ಗೆ
the guidance issue matter. What is the requirement for establishing the poultry farmers? And where is not the aspect where is not poultry farming, planning, and have to take care of everything. Users.
Yes, please come to the application that is filed. Application. Yes.
And it was obnoxious and there hence have right
ಇವಾಗ ಈ ಪೌಲ್ಟ್ರಿ ಫಾರ್ಮ್ ಇಂದ 500 ಮೀಟರ್ ಅಲ್ಲಿ ಮನೆಗಳಿದೆ ಅಂತ ಎವಿಡೆನ್ಸ್ ಹೆಂಗ್ ಕೊಡೋದು ಅಂತ ಹೇಳಿ. ಈ ಪೌಲ್ಟ್ರಿ ಫಾರಂ ಇಂದ 500 ಮೀಟರ್ ದೂರದಲ್ಲಿ ಎಷ್ಟು ಮನೆಗಳಿದೆ ಅಂತ ತಿಳ್ಕೊಳ್ಳೋದಕ್ಕೆ ಎವಿಡೆನ್ಸ್ ಹೆಂಗ್ ಕೊಡೋದು? ಕರೆಕ್ಟ್ ಕರೆಕ್ಟ್. ಫೆನ್ಸಿಂಗ್ ಅಲ್ಲ ಸರ್, ವಾಸನೆ ಬರುತ್ತೆ. ಅದಕ್ಕೆ ಕೇಳಿದ್ದಾರೆ. Is only for the purpose of considering the application for interim injunction.
Implementation is granted.
Ex parte order is granted. Ex parte order of injunction is granted.
Not the legal. Legal affidavit.
Ex parte order of injunction is confirmed already.
Therefore, it requires application, offer modification, offer to meeting, you want to manufacture, not to pay. It is not the measurement has to be carried out.
Still, anything else? Yes.
And they're not before, they're not after.
So what is the application that was filed in this case? For what? To do what? That's ಆಮೇಲೆ ಬರುತ್ತೆ ಅಂತ ಹೇಳಿರೋದು. This is only for the limited purpose of considering whether the interim order of injunction should be confirmed or not. That is the reasoning. For example, today. Yes. I'll give you an example. Tomorrow, there is one electric crematorium which is established next to your house. You file a suit for injunction saying that. No, I'm trying to tell you how Order 39 Rule 7 will operate. The court doesn't grant an injunction. Interim order of injunction is not, ex parte order of injunction is not granted. Tomorrow, the electric crematorium starts functioning. You will file an application to draw samples. Can you say that he should wait for the evidence to happen?
No. The incident is not. After granting the injunction order, this application is filed.
Why not is what I'm asking you. This is not. That is it. That is why I asked you whether the ex parte order of injunction is confirmed or not.
But it has not been confirmed. It has not been continued.
So therefore. So we will simply say that this order of appointing a commissioner will be for the limited purpose of considering this application, nothing else. It will not be treated as evidence for the purpose of the suit. Evidence has been marked for level. The defendants in OS number 5 of 2016 on the file of the Principal Civil Judge in JMFC Tirthalli have filed this writ petition agreed by the order dated 26/8/2016, by which an application filed by the plaintiff under Order 39 Rule 7 was allowed. The short facts that are the subject matter of OS number 5 of 2016 are that the plaintiff sought for perpetual injunction against the defendants who intended to establish a poultry farm in their property. The plaintiff contended that the poultry farm was established in a residential area where there were several dwelling houses, schools Anganwadi, a government, a well sunk by the government, panchayat office, etc. He stated that the village panchayat had refused to grant license permission to authorize the defendants to establish a poultry farm. Full stop. Since the defendants pursued their intention to establish the poultry farm, the plaintiff filed the suit for perpetual injunction. The trial court granted an ex parte order of injunction on an application filed by the plaintiff. Full stop. Later, the defendants entered appearance and claimed that the poultry intended to be established by them was 600 to 800 meters away from the residential locality full stop. They also alleged that there are no schools or well sunk by the government or office of the panchayat, etc. within 600 to 800 meters from the poultry. Full stop. The the ex parte order of injunction that was granted was extended from time to time and later extended from time to time. Full stop. An application was filed by the plaintiff under Order 39 Rule 7 of the Code of Civil Procedure for appointment of a commissioner to verify whether there were any dwelling houses within 500 meters from the poultry farm. Full stop. This application was favorably considered by the trial court. And an advocate was appointed as a court commissioner to make a local inspection as prayed for in the application. Full stop. Being agreed with the said order, the present petition is filed. The learned counsel for the petitioner submitted that the application amounted to collection of evidence which is impermissible in a suit for injunction. He submitted that the plaintiff should adduce evidence and only if the court considers it appropriate to appoint a commissioner, provisions of Order 26/9 could be invoked. And the plaintiff is not justified in invoking the provisions under Order 39 Rule 7. He also submitted that the purpose of appointing a commissioner under Order 39 Rule 7 is underscored in the judgment of the High Court of Madhya Pradesh in Ashok Parvat versus Sudarshan, where he relied upon paragraph number 11, which reads as follows. Full stop. He therefore submits that the trial court committed an error in allowing the application, which was akin to fishing evidence for the plaintiff. Full stop. Next para. The learned counsel for the respondents is absent. Therefore, this court did not have the benefit of his contentions. Be that as it may, the contention of the plaintiff was that the poultry established by the poultry to be established, poultry established by the defendants, lay within 500 meters we contended that is that the Pollution Control Board had issued guidelines fixing the norms for establishment of a poultry. Full stop. He submitted that such poultry farms should not be established within 500 meters from residential areas or major drinking water sources, etc. He submitted that the defendants had established the poultry farm within 500 meters, and therefore, the same had to be ascertained for the purposes of considering the interim order of injunction sought for. Next, the learned counsel for the full stop. The learned counsel for the petitioner did not dispute the fact that the Pollution Control Board, Karnataka State Pollution Control Board, has prescribed the rules and regulations relating to establishment of poultry farms. Full stop. All that the plaintiff in this application is seeking for is to inspect the poultry farm and find out whether this prescription in law is complied by the defendants or not. Full stop. This obviously could be for the limited purpose of considering the application filed by the plaintiff for interim injunction and cannot be used as evidence at this stage of cannot be used as evidence for the final disposal of the suit. Full stop. In that way of the matter, this court does not consider it necessary to interfere with the order passed by the trial court. In view of the above, the petition is dismissed, but subject to the observations contained herein above. Mr. Sriram indicates the case Natraj, Harsha D. Joshi, Ramanjanaya. This Harsha D. Joshi. Yes. So what is this suit for? Interim or yen?
And as per the model, legal value of the property and you say, subject matter of property for therefore, we lost that.
ಅದೇ 30-40 ನಾ 60-40 ಎಲ್ಲಿ ಕೊಡಿಸ್ತಾರೆ ಹೇಳಿ
FA for the respondent, my lord.
That is the 7 I lost. 29 I get to get position of property.
That's your headache. That's your headache. ಎಲ್ಲಿಂದ ಕೊಡಿಸ್ತಾರೆ ಹೇಳಿ No, not as per the guideline value.
And one the order,
65.
Actually, page number 30 onward.
Yes, please. Yes.
pertaining to as of the date of the offense, that is
Sir, is the money paid? Is the money paid? ನೀವು ಯಾವ್ದೋ ಕಾಲ ಡಿಗ್ರಿ ಆಗ್ಬಿಟ್ಟು ಇವಾಗ ಅವತ್ತಿನ ಡಿಗ್ರಿ ಇವತ್ತು ಕೊಡಕ್ಕಾಗತ್ತಾ? If you had paid it, today's guideline value, today's value, ಎಷ್ಟಿದೆ? So the agreed to be sold to the degree holder, year 2007. 2007. ಎಷ್ಟಿದೆ? $400 per square feet. ಇಲ್ಲಿಲ್ಲ ಇಟ್ಟು ಮಾಡೋದಿಲ್ಲ ರೇಟ್ ಇಲ್ವಲ್ಲ? ತ್ರೀನಲ್ಲೇ ಹೌದು. ಇಟ್ಟು ಮಾಡೋ ಕಾರ್ಪೊರೇಷನ್ ಮತ್ತು ಸಿಎಂಸಿ, ಬಿಡಿಎ ಮತ್ತು ಬಿಎಂಆರ್ಡಿ ಬಡಾವಣೆಗಳು 2000, ಗೃಹ ನಿರ್ಮಾಣ ಸಹಕಾರ ಸಂಘ 1000, ಪರಿವರ್ತನೆ ನಿವೇಶನ 1000, ಮಹಾನಗರ ಪಾಲಿಕೆ ಮತ್ತು ನಗರಸಭೆ ಸರಹದ್ದಿನ ನಿವೇಶನಗಳು 1000 ರೂಪಾಯಿ. So it comes within 1000. CMC number ilva? When you are selling the property, what number you give? So site number 16 is CMC limit ಒಳಗೆ ಬರುತ್ತೆ ಅಂತ, ಪಂಚಾಯತಿ ಲಿಮಿಟ್. ಸರ್ ಇಲ್ಲ ಸರ್ವೆ ನಂಬರು ಇಲ್ಲ ಗ್ರಾಮ ಠಾಣ. ನೀವು ರಿಜಿಸ್ಟರ್ ಮಾಡಿಸುವಾಗ ಗ್ರಾಮ ಠಾಣ ಹಾಕ್ತೀರಾ, ರಿಜಿಸ್ಟರ್ ಮಾಡಿಸುವಾಗ ಗ್ರಾಮ ಠಾಣ ಹಾಕ್ಬಿಟ್ಟು ರಿಜಿಸ್ಟರ್ ಮಾಡಿಸ್ಬಿಡ್ತೀರಾ. ಈ ಕಾಂಪನ್ಸೇಷನ್ ಕೊಡುವಾಗ ಸರ್ವೆ ನಂಬರ್ ಇರ್ತೀರಾ. So therefore it comes within gram thana. ₹1000 ಅಂತ. Yes, house list number ಹಾಕಿಲ್ವಾ? House list number ಹಾಕಿಲ್ಲ ತೆಗೀರಿ. ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ವಿತೌಟ್ ಆಯ್ತು, ಅಗ್ರಿಮೆಂಟ್ ಫಾರ್ ಸೇಲ್ ಹಾಕಿ, ಹೌಸ್ ಲಿಸ್ಟ್ ನಂಬರ್ ಹಾಕೊಂಡಿರ್ತೀರಾ? ಹೆಂಗೆ 16 ವಿತಿನ್ ವಿಚ್ ಯಾವ ಏರಿಯಲ್ಲಿ ಬರುತ್ತಿದ್ದು? ಇಟ್ಟು ಮಾಡೋ ಕಮ್ಸ್ ವಿತಿನ್ ಕಾರ್ಪೊರೇಷನ್. ಸರ್ ಇಟ್ಟು ಮಾಡೋ ಕಾರ್ಪೊರೇಷನ್ ಬರಲ್ವಾ? ಏನ್ ಹೇಳ್ತೀರ ನೀವು? BBMP limits in 2006 there was a notification bringing Ikkamodu within the limits of BBMP in 2006. ಬೇಡ ಇದ್ಯಾಕೆ ಸುಮ್ಮನೆ ಒಂದು ಸೈಟ್ ಕೊಡಿಸ್ಬಿಡಿ, ಗೆಟ್ ಎ ಸೈಟ್. ಲಿಟಿಗೇಷನ್ ಪ್ರಾಪರ್ಟಿ ಸೇಲ್ ಮಾಡೋದು, you buy a site. You compromise petition, please come to the compromise petition. Note, what if at all the defendant loses the above said case, he will give the alternate site in some other survey number in the same layout, or he will repay the market value amount to the plaintiff. $2007 ಪ್ರಕಾರ ಏನ್ ಕೊಡೋದಿಲ್ಲ. Have you paid the money? If you paid the money, what you say is right.
No, he has not paid the entire money. He has paid only 2 lakhs.
Hmm.
12 lakhs of 50 lakhs.
Hmm.
And the consideration amount is 10 lakhs of 50 lakhs. 3 lakhs of 50 lakhs.
24 lakhs, 24 lakhs, idur prakara. Plus.
Actually, otherwise I will achieve the law. It's not a converted land.
Yes. Yes, Mr. Joshi. 1,000 rupees per square feet, Joshi. Mr. Kar Joshi. Joshi, ಈ ಕಡೆ ನೋಡಿ. Mr. Joshi.
Please, my lord.
Are you willing to take 1,000 rupees per square feet?
I'll ascertain with my client, my lord, and I'll come back on Friday. My lord, if they are willing, my lord, I don't know, because last time also, my lord, I said let there be a compromise. And my lord, I'll convince my client to take 1,000 rupees, my lord, and finish the litigation.
Right,
Lord, may kindly
1,000
call it on Friday.
1,000 rupees.
I'll convince my client, my lord. ಅದನ್ನ ಹೇಳ್ತೀನಿ. I will convince my client to take 1,000 rupees, my lord, and finish with the litigation.
ಇನ್ಮೇಲೆ ನೀರು ಕುಡಿಬೇಕು, ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಕರೆಕ್ಟ್ 2 ಲಕ್ಷ ರೂಪಾಯಿ ತಗೊಂಡಿಲ್ವ ನೀವು? 2 ಲಕ್ಷ ರೂಪಾಯಿ ತಗೊಂಡು ಅವ್ರಿಗೆ ಇಷ್ಟು ವರ್ಷ ನೀರು ಕುಡಿಸಿದ್ರಲ್ಲ.
Because one way or the other, my lord, the litigation has to come to an end.
Solid. Yes, ಯಾವತ್ತು ಬೇಕು? When do you want it?
Monday, my lord, will.
The request of the council for petition respondent is on Tuesday, date for ಮುಂದಿನ ವಾರ. Interim order is extended till the next date. Yes. Mr. AV Gangadhar. Mr. HK Satish. Yes. 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 This is an ex parte decree. So an ex parte decree. ಇದೆಯಾ? This is the evidence of DW1. Copy दिया. Yes, Mr. Satish, the report of the court commissioner. Report of the court commissioner says that the property which is granted to Ajarabi is within the road. It might be situated, but you are not required to regularize it. Who asked you to do it? Please have a look at this commissioner's map. Commissioner map note. Yes, Mr. Om Prakash. Office to Arthur dismiss. Lakshmaya. Om Prakash. Om Prakash, Niva. Both of you are lawyers. And you are fighting your own case. If you want to not really, Satish, don't waste time. The request of land council for respondent number one. Yavat note. Nindala. Yavat 2014 writ petition, Mr. The request of the council for respondent number one listed as the last time. No adjournment will be given on the next date. It is made clear that no adjournment shall be granted on the next date of hearing. Well, yaar, please be seated. Yes, Mr. Om Prakash. Yes, okay. So what is a suit for? Declaration. What is the application now for it? Huh? Please wait. Who are you? You are the plaintiff. You are the plaintiff. Where's the order passed to the court? Make sure, yep. Both. Please read. Who are you to say that? Who are you to say that the wakalat has to be rejected? Different ಹೇಳಿದಾರ ನಮ್ದಲ್ಲ ವಕಾಲತಿ ಸಿಗ್ನೇಚರ್ ಅಂತ. ನಿಮ್ಮಿದ ವಕಾಲತಿ ಕನೆಕ್ಷನ್ ex officio president yaar we Lakshmaya so yaar is ex officio president and others yaar What is the plaint? ಅಲ್ಲ ನೀವು ಜಿ ರಾಮಯ್ಯ ಅಂತ ಮಾಡಿಲ್ಲ, ಕರ್ನಾಟಕ ಸ್ಟೇಟ್ ಎಜುಕೇಶನ್ ಫೆಡರೇಷನ್. ಜಿ ಕೆ ರಾಮಯ್ಯ 100 ವರ್ಷ ತನಕ ಬದುಕಿರ್ತಾರ.
Government is not. The second class is state director department. That is there. Now we pick up the names who are engaged in it. And the suit is filed, the name is there. Name on it. Actually, the name of the designation. But that is very best. Second, we should not mention the name of I just them best. He is not prepared. Without knowledge of the dependence of that's how the last 10 years, several applications for issues also very
Suit is still pending. Who are you? You are the secretary. Venkateshaya. So who are you? Om Prakash. Where are you in this? You suit al ನೀವು ಎಲ್ಲಿದ್ದೀರಾ? ಎಲ್ಲಿದ್ದೀರಾ? What is this education federation? It's a society. Karnataka State Education Federation Association. Certificate unregistered, and you filed a suit. What is what is your locus to file a suit? Unregistered body. How can an unregistered body come to the court? I am asking you. How can an unregistered body come to the court with a cause of action?
Association representative.
You're not a registered body. You will dismiss the suit also. Suit to dismiss market. Because you're not a registered body. You're not a person. You're not a person, either a living person or a natural person or a legal person. Hinge. ನಿಮ್ಮ ಅಸೋಸಿಯೇಷನ್ ಯಾರು? ಹೆಂಗ್ ಮಾಡಿದ್ದಾರೆ? ಹೆಂಗ್ ಮಾಡಿದ್ದಾರೆ ಎಲೆಕ್ಷನ್? ಮಾಡಿದ್ಮೇಲೆ ಎಲ್ಲ ಒಂದ್ ಕಡೆ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಬೇಕಲ್ಲ. ಇಂಥವ್ರು ಓಂ ಪ್ರಕಾಶ್ ಸೆಕ್ರೆಟರಿ ಅಂತ ಎಲ್ಲಾದ್ರೂ ಅಫಿಷಿಯಲ್ ರೆಕಾರ್ಡ್ ಇದೆಯಾ? ನಿಮ್ ಬಾಡಿಲಿ ನೀವು ಮಾಡ್ಕೊಂಡಿದಿರಲ್ವಾ? So therefore, unless you register, you don't become a legal body. It was a criteria from the year 1860 when the Societies Registration Act came into being for the first time. Government might have done anything. You are not a registered body. If you are not a registered body, you don't have right to file a suit. We are adike close ಮಾಡ್ತಾ ಇದೀವಿ. The law is decided, Mr. Bangalore Club judgment ಇದೆ ನೋಡಿ. Sir, it will be, you might continue to get it, but you can't file the suit. They can go to the government and get it cancelled. So So long as you're not a registered body, you're not a legal person. If you had come to the court and said, Om Prakash, non owner, I am the proprietor, I am the owner, now we can do it. No. Nobody has considered this, mister. Nobody has considered this question. First time we are hearing it. Hope this is not the last time. How can an unregistered body file a case? Please show me some law. Yes. Astana? Huh? No, we are closing your suit. Suit close market. Law is settled. I am not against you. The law is settled. Unregistered body cannot come to the court. It doesn't matter. It doesn't matter. Bangalore Club, Britishers Marogido. Bangalore Club. You register it and then file. Why to suit right? Yes. Anything else? Yes, Mr. Lakshmi. No. It's a registered body. Where is it? Where are they mentioned? It's a registered body. I think here it's a registered body. I Tadala video Wakara Deli said only that. Who is this ex officio president, Karnataka State Education?
see believing
You're also a lawyer and also a secretary. You continue to be a lawyer and also a secretary. ಯಾಕೆ ಹಿಂಗ್ ಮಾಡ್ತೀರಾ ಓಂ ಪ್ರಕಾಶ್ ಅವರೇ? ಯಾಕೆ ಸುಮ್ನೆ ಬಂಡೆ ತಲೆ ಮೇಲೆ ಹೇಳ್ಕೊತೀರಿ? ಇಲ್ಲ ವಕಾಲತ್ ಮಾಡಿ, ಇಲ್ಲ ಸೆಕ್ರೆಟರಿ ಆಗಿ. ಅಲ್ಲ ಸರಿ, ಸಂಸ್ಥೆ ಸರಿ ಹಂಗಿದ್ರೆ ವಕಾಲತ್ ಬಿಡಿ, ಸಂಸ್ಥೆ ನಡೆಸಿ. You can't be a lawyer and a secretary, mister. You can't hold any office of profit. What is this? Yes, please go and put your advocate check for me. ಏನ್ ಮಾಡ್ತಿದ್ರ ನೀವು ಓಂ ಪ್ರಕಾಶ್? ಏನೋ ಮಾಡಕ್ ಹೋಗಿ ಇದ್ ಮಾಡ್ಬೇಡಿ. Don't put it on yourself. Our Council of India could. There must be a disqualification. You cannot be an advocate and also hold an office. Look, check ಮಾಡಿ ಎಲ್ಲೋ ಒಂದು ಇದಿರಬೇಕು. You can't be employed. You're not drawing any salary. You're not drawing any salary. I tell you, but we'll consider that. ಅಷ್ಟೇನಾ? Yes. Karnataka State Education Federation how is the ex officio director? How? Sir, Karnataka State Education Federation idanna represent madadike. What is the power of this man who is the ex officio president? What is his power? Rules ಅಲ್ಲಿ ಇದೆಯಂತ ಎಲ್ಲಿದೆ ಅದು? ತಂದಿಲ್ಲ ಅಂದ್ರೆ Mr. 2015 writ petition. Sir, ಅದೆಲ್ಲ ಬಿಟ್ಬಿಡಿ. Please show Karnataka State Education Federation can be represented by an officer of the department. Really there. Mister, don't come to the court like this. Please come with my bylaws. ಅದರಲ್ಲಿ ex officio ಅಂತ ಇದ್ರೆ ಅಂತ ಕೊಡಿ. ಎಲ್ಲ ಹಳೆ ಕೇಸ್ಗಳಲ್ಲಿ ಯಾಕೆ? You will present it, but why so long? 2015 writ petition. The request of the council for respondent, request of the respondent list on Dwarak. Fourteenth. Yes. Israel ಹಳೆ ಕೇಸ್ಗಳು ಮುಗಿಸ್ಬೇಕು ಅಂತಿದ್ವಿ ನಾವು. 1997 ಇಸ್ವಿ ಸೂಟು 25 ವರ್ಷ ಆಯ್ತು. Please have some concern. It's a shame on the system. ಅಲ್ಲ next. If you want to come, you come. Otherwise, we'll close it. ಎಲ್ಲಾದ್ರೂ ಹೋಗಿ ಬನ್ನಿ ಅದನ್ನ. Yes, next. Mr. Sheshagiri Rao. Mr. T. Sheshagiri Rao. Mr. L. Srinivas Babu. There is no representation for the petitioner. The petitioner is dismissed from her person. Yes. ಹೇಳಿ. What is the suit for? Yes. What is the application? They are for the defendant. Ah, 6 years. 6
Now it is for argument of the defendant. My argument is wrong. When the matter is posted for the arguments of the defendant, the come up with these applications. Protocol member committing the president. There is no.
What is the counterclaim? What is the counterclaim? Yes, admit to. ಅಷ್ಟೇ. ಹಾ. 6 to 17 ಅಮೆಂಡ್ಮೆಂಟ್ ಏನು ಇನ್ನೊಂದು ಪ್ರಾಪರ್ಟಿ ಇದೆ ಅಂತ. 6 to 17 is for what? For what?
For showing the property.
So additional property they want to bring in. Number one. I will counter claim ಏನು? How are you prejudiced? How are you prejudiced?
No, that is not the property. Both are claiming under one rushing particular. As a first instance, they are not come up with this defense. The first instance, they said there is no executor of the joint family. Therefore, they try to prove that there is a bill executed by the rushing Murthy. That has been rejected by the trial court as well as by the Sarabha. Now they have come up with this defense that there is one more property. Evidently, product that should be the solver.
Who is the owner of this property?
But they said that I'm the owner of the section regarding that property.
ಆಯ್ತು ಫೈನಲ್ ಡಿಕ್ರಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಎಲ್ಲ ಮಾಡಬಹುದಲ್ಲ, they can insert additional property.
Only for partition, they are not. The first instance, they have to dispose their defense.
Are you the owner of this property? Are the plaintiffs the owners of this property?
You are
the owner of the property. How did you get this? ಏನಪ್ಪ 2004 ಸೂಟ್ ನೀವು ಇನ್ನ you can file an application, the final decree. Why you want to unnecessarily halt the suit? Final decree ಹಾಕೊಳ್ಳಿ. Where is the application? What have you mentioned? Let the suit go on. We will permit you to file an application in the final decree proceedings. Requisition is allowed. The requisition is allowed. The impugned order is set aside. Consequently, the application filed by the defendant number 1 to 3 in the OS number 2192 of 2004 are rejected. The trial court is directed to dispose of the suit within a period of 6 months from the date of receipt of a certified copy of this order. It is open for the defendants to file appropriate application in final decree proceedings. In final decree proceedings, and if such an application is filed, the final decree court shall pass appropriate orders. Final decree nalli ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ, ಇದೇ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲ. Yes.
I appear for the first respondent, my lord.
Yes. Please come again. But then it's not in accordance with the law. It's not an equitable partition. Hanmaka yaru decree holder, the FDP plaintiff. She is also signed the partition. And the applicants are the legal heirs of Hanmaka. What is the property given to Hanmaka in this partition?
Only 50,000 rupees.
Let the final decree court even decide that. Why should they file one more suit? Why not? It is not a compromise before the court. Correct. Correct. Your Hanmaka sign hakidro illa anta enga tirmana madodu. Whether Hanmaka has signed it or not. There are other children under Hanmakanchi Makla.
Not Hanmaka's.
Yes. So let the final decree court even consider this. Yes, madam.
You lordships may kindly see Muniraju, son of Hanumaka, who is the second son of Hanumaka, who is none other than the son-in-law of the petitioner herein, Patalappa, original petitioner. His daughter is a Parijata. And Hanumaka is LTM holder. She was 85 years old as on the date of the execution of this partition deed. And she was living with her second son and daughter-in-law, that is Parijata, who is the daughter of this Patalappa, that is original petitioner. All of them have colluded and they made this partition deed. The lordship may kindly see, partition deed is of the year 2013.
Let the court decide the claim. The court says that issue has to be decided by the civil court. Let the court say that.
Fraudulent document, my lord. 2014 she died. This document was never produced before the FTP proceedings. FTP is still pending.
The respondents in FDP, respondent number 3, respondent number 3 in FDP 3 of 2008, in the file of the so and so court has filed this petition challenging an order dated 4/3/2016. Sorry, 23/6/2000. 4/3/2016. Order dated 4/3.
Order dated 4/3/2016.
Signature.
4/3/2016. Yes, 4/3/2016.
4/3/2016. In terms of which, the court allowed an application filed by the legal representative of the petitioner therein. Stop next. The suit in OS number 138 of 2005 was filed for partition of the 1/4 share of the petition of the respondent. 1/4
Petitioner in
of the
FDP.
Hanumakka.
Yes, Hanumakka.
The said suit was decreed. Thereafter, FDP 3 of 2008 was filed to enforce the preliminary decree. To stop during the pendency of the proceedings, Srimati Hanumakka died. To stop. An application was filed by the legal representative of Hanumakka. The said application was opposed on the ground that the said Hanumakka had entered into a partition with the respondents in FDP 3 of 2008, in terms of which certain money was paid to Hanumakka and the 26 guntas was given to the share of Srimati Parijata. Srimati Parijata.
Parijata is not. Parijata is it's daughter of this petitioner, that is Patalappa. Original petitioner Patalappa. There is collusion.
Yar
Parijata Patalappan Magalo.
99 gunte yarge. Parijata is Patalappa's daughter.
Yes, my lord. And Muniraju is his son-in-law. Both of them colluded with Patalappa and they created this partition deed. Impleading applicant is another son.
The sum of rupees 50,000 was paid to Srimati Hanumakka. Full stop. It was contended that the legal representative of Hanumakka had no right to come on record as Srimati Hanumakka had given up her share in the social properties. The legal representative of Hanumakka contended that Hanumakka was aged 85 years and therefore the partition deed set up by the respondents in FDP 3 of 2008 were fraudulent, and therefore the final decree court was bound to look into the compromise decree. The partition deed was entered into. Stop. The trial court, after considering the contentions, allowed the application in terms of the order which is impugned in this petition. The Learned Counsel for the petitioner submits that since the parties have already entered into a compromise, the same has to be challenged before the competent court and not before the final decree court. Full stop. He submitted that Hanumakka was also a beneficiary of certain money, and therefore, the legal money and some of the legal representatives of Hanumakka had consented to the partition deed, and therefore the other legal representative of Hanumakka cannot come on record in the final decree proceedings. For contrast, the Learned Counsel for the respondent submitted that the partition deed was fraudulent as Hanumakka was aged 85 years and she was
illiterate lady, illiterate, and she was suffering from old age ailments.
And an illiterate lady and was suffering from various ailments. To stop. He submitted that the same was not obtained voluntarily, was not executed voluntarily, but was not executed voluntarily. You have admitted the signature of Hanumakka?
No, my lord, I am not admitting. Because she is no more. This was the partition deed is of the year 2013. She died in 2014. This document was not produced before the even FTP proceedings.
It also contended that this document was
dishonorable
not executed by Srimati Hanumakka. If the partition entered into between the parties is not before the court, the same cannot be pressed into service to shoot down the final decree proceedings. If the legal representative Hanumakka claims that there was no equitable partition, in line with the preliminary decree, is entitled to adjudicate the same before the final decree court. He can also assign the correctness of the partition allegedly entered into by Hanumakka We'll stop. In that view of the matter, comma, the trial court has permitted the applicant to come on record to establish the same. This court does not find it necessary to interpret the order. Yes. When this was it's only for one rule 10th on it. Right, is disposed on the above terms. ಯಾರು ಇವ್ರದ್ದು ಕೊಡಿ ನಿಮ್ದು ಯಾವ್ದು ತಗೊಂಡು ಹವಾಲ್ದಾರ್ ಅವರು ಅದು 4 ಗಂಟೆಗೆ ಯಾಕೆ ತಗೊಂಡೆ ಅಂದ್ರೆ ಟೈಮ್ ಆದ್ಮೇಲೆ ತಗೋಬೇಕಲ್ಲ ಇಲ್ಲ ಸೀರಿಯಲ್ ವೈಸ್ ಕರಿಬೇಕು ಎಷ್ಟು ಹವಾಲ್ದಾರ್ ಕೊಡ್ರಿ ಯಾವ್ದು Yes, Mr. Hawaldar, what is your case? Yeah. Connection E, huh?
After 16 and 19, what is the matter? The schedule will be offset. Yes, these notices it does indicate the agenda to be with this meeting. On 11/8/2021, the election just matter. The insurance has been directed out of the candidate. They want for a meeting, they have to indicate what is the agenda is. This notice is not.
Illegal notice. ಇವಲ್ಲ ಇಲ್ಲಿ 31/5/2022 ಏನಾಗಿದೆ 2/9/22 yes
Subject ನಾವು ನಿಮ್ಮ ಟ್ರಸ್ಟ್ ಮೀಟಿಂಗ್ ಹಲವಾರು ಬಾರಿ ಕೇಳಿಕೊಂಡು ನಾವು ರಿಜಿಸ್ಟರ್ ಪತ್ರದ ನಾನು 9/9/21 ವಿಚಾರಣೆ ಪತ್ರ ಬಂದಿರ್ತದೆ ಆವಾಗ ನಾವು ಪತ್ರದ ಬಗ್ಗೆ ಎರಡು ಪತ್ರ ನಾವು Now, Lordship has kindly seen this 224.
Only the trust read rule 24. Yes. This rule 24. Really.
24. It is page 92.
Let us see what is the term of the president?
3 years. And it can be continued.
3 years. Early course.
But he was appointed in 2015 and he was continued in 2019 also.
Course, sir. Early the president will. President term ಎಲ್ಲಿದೆ?
Lordship has kindly come to Annexure D. They will copy in 397. They will copy at 398. We come to question number 5. Section of being very
ಅದಲ್ಲ ಸರ್ ಕೇಳಿದ್ದು ನಿಮ್ಮ ಬೈಲಾಸ್ ಪ್ರಕಾರ ವಾಟ್ ಇಸ್ ದ ಟರ್ಮ್ ಆಫ್ ದಿ ಪ್ರೆಸಿಡೆಂಟ್ ಎಲ್ಲಿದೆ ಅದು
The term of office of the Board of Trustees, coming under the above board of ordinary period, data nominated or elected the Board of Trustees. Provided that any be removed or others may be nominated anytime. If we found any discrepancy and assignment, the object is state by law. Oh, this move 24 hours going to bring to a topic. Okay, page 92, room 24.
Yes.
This 24 cross forum better. The recognition from state is again. That has to be discussed in that. Now, we also can take the appreciate that whatever notices they give, it is not contained that we are deciding it and it is going to be removed. As an object page 88/2021, the mortgage is there. The year certificate is number is last to 120 dollars and your R1 Apparently, dollar it will be there. Let me say that the one is here also they do not speak anything about that.
Where are the other notices? ನಮ್ಮ ಪತ್ರ ದಿನಾಂಕ 9/7/21 ಎಲ್ಲಿದೆ?
9/7
12/7 9/7 ನೋಡಿ. ಈ ಮೂಲಕ ನಿಮಗೆ ಹಲವಾರು ಬಾರಿ ಕೇಳಿಕೊಂಡರು.
ಒತ್ತಾಯಿಸ್ತಾರೆ ಆದ ಕಾರಣ ತಾವು ಯೋಜನೆಗಳಿಗೆ ಈ ದಿನಾಂಕ 9 ಟ್ರಸ್ಟ್ ಮೀಟಿಂಗ್ ಕೊಡಲಾಗಿದೆ. ಈ ಪಕ್ಷ 4ನೇ ಮೀಟಿಂಗ್ ಮಾಡುತ್ತೇವೆ. He has been diverted of his trustee. So, no way they say that you are going to be removed because of the mismanagement of. So, the lordship will kindly appreciate what the trial court has said.
Yes.
Section B is out of the trial court.
Have you responded to any of these people saying that you have not indicated the agenda? Agenda in the Madak Parala ಅಂತ ಹೇಳಿದಿರಾ? ಆಯ್ತು, ನೀವು ಹೇಳಿದಿರಾ? Have you asked? Where are those replies?
When they wanted to remove him, certain deeds and all that. The agenda is still about it. So, to Lordship, I kindly come to paragraph 15 of the order of the trial court. Page 71. Anybody to read?
Yes.
On refusal of the letter issued to the defendant on 31/7/21. The noted that the subject meeting to the head on 11/8/21 read that the expiry of the term of proceeding and reading the relevant book about the activities of trustee. This term of proceeding to the agenda is the council of the country not to the honorary president Karnataka department of started sorry for the briefing that of the violation of the road. But on the letter date issued by 31/7/21 is noted. The letter issued to the secretary, he is one of the officers appointed along with the plaintiff. He suggested it is a relevant and on government and be found in legal or not, need to be decided at trial. At present stage, on careful reading of evidence materials of the court, it can be said that even though the plaintiff is not prima facie, the balance of convenience do not lie in his favor. He lies in favor of the defendant because the Granbury Temple Trust, Environment Support Trust, the public private trust, and every 2 years, many schools are carried out. Social education boarding is taken care of. The education case are being taken. Defendants have already formed a committee on that. I think it's the case with referring to that very exempted. It will affect the company in the trust. There are allegations over the arbitration. It is different to a fair, so appointed to be taken out of not significant. So let us deal with the house. Also, this will deal with something of the also. That the trial court holds that in the prima facie case is there. So, what do we understand in the prima facie case? In that case where he has got a cash balance in the case and there is a 100% surplus because of that. Other than technically, my lord is that on 11/8/2021, when he was divested of his certificate, so that the meeting did not contemplate the agenda about the disputes and removed from the certificate.
So was he removed from the trusteeship?
Yes.
From the office of president?
The president is also the trustee. So you entire thing is bylaws and the trustee.
Correct. He continues to be a trustee.
Now he doesn't allow to function.
Oh.
This committee of all the 6, they are functioning it.
Yes.
No, and they don't have the 11/8/2021 resolution. Contrary to the bylaws and the scheme. Something like that. Consider this. You can do it. No, the argument that you have made that balance of convenience.
Yes, but if no other president is elected, president is not elected after the death of that person. ಯಾರೋ ತೀರೋಗಿದಾರಲ್ಲ, ತೀರೋದ್ಮೇಲೆ ತಾನೇ ಇವ್ರನ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ರು. Correct, 2016 or 2019 ಅಲ್ಲಿ. 16. When was the next? 2019. 19 ಅಲ್ಲಿ ತಿರ್ಗಾ ಒಂದು ಎಕ್ಸ್ಟೆನ್ಷನ್ ಇದೆಯಲ್ಲ. After 2019, there is one more extension. 6/11/2019. ಎಲ್ಲಿದೆ ಆ ನೋಟಿಸ್ಗಳು? So where are those notices? ಅವ್ರಿಗೆ ಹೇಳ್ಬೇಕಲ್ಲ ನೋಟಿಸ್ ಕೊಡುವಾಗ ಇಂಥದಕ್ಕೆ you should ಮೀಟಿಂಗ್ ಏನಕ್ಕೆ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳ್ಬೇಕು ಬೇಡವಾ? ಎಲ್ಲಿದೆ ಅದು ಕನೆಕ್ಷನ್? (31/7). ಲೆಕ್ಕದ ಬಾಬು ಅಧ್ಯಕ್ಷರ ಆಯ್ತು. ಬಟ್ ಸಭೆಯ ನಡವಳಿಕೆ ಪುಸ್ತಕ ಹಾಗೂ ಇತ್ತೀಚಿನ ಖರ್ಚು ಇತರೆ ಲೆಕ್ಕದ ಬಾಬ್ತು ಅದ್ರ ಬಗ್ಗೆ Yes, sir. When was the suit filed? 31/7 suit notice ಕೊಟ್ಟಿದ್ದು. suit ಯಾವ ಮಾಡಿದ್ದು? It is after your term came to an end. November 22 ಆಗದು. Yes, it might be expedited in. Yes, sir. But there is some indication as to what should be the agenda.
On the date of this notice, the third had not come to an end.
Correct. ಮುಂದಿನ ಮಾಡ್ಬೇಕಲ್ಲ, ಯಾರನ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡ್ಬೇಕಲ್ಲ.
Appointment ಮಾಡಬೇಕು after 5/11 only.
No. Why should you wait till 5/11 when your term comes to an end? Why can't elections be held in a
Such committee had to be appointed only after the expedition of 5/11.
ಎಲ್ಲಿದೆ ನಿಮ್ಮ ಬೈಲಾಸ್ ಇದೆಯಾ? Paragraph?
Kindly come to page 86. Term of office. Now, notice of the board of trustees. I mean, the whole board is nominated with Peter, nominated or the discrepancy or misalignment express opinion of all the trustees, provided that each trustee is outstanding experience unless removed earlier, continue to go to office, the nomination of the experience. Therefore, removal is to be on the basis of some misalignment or something that again be completely trust. That is not the case here. And then it will continue also.
No, but if you don't function according to the trust, what should be done?
So my substitute to Dr. is that this resolution dated immediately to the is concept the bylaws of the. Therefore, that second elevation has no legal effect in the eye of law. One and 7 to 8 was supporting the case of the 1 to 6 to cause the resolution of 11 and 21. They are trying to.
The board of trustees is empowered to remove or nominate any trustee members at any time if found not satisfactory to the service of the subcommittee to form members also. Sorry, sir. You please find out who can respond. Suit ನಡೆಸ್ಕೊಳ್ಳಿ ಅಷ್ಟೇ. Suit ನಡೆಸ್ಕೊಳ್ಳಿ ಹಿಂದೆ. Yes.
After 5 years, the basis for removal has no legal foundation. How could the respondent continue? They have done contrary to the bylaws of the society.
This is justify. What justifies the removal? What is the justification for his removal? What is the basis for removal of the petitioner? How do you just? I think misconduct process ilva. Removal process ilva. ಎಲ್ಲಿದೆ ಅದು ಮಿನಿಟ್ಸ್ ಎಲ್ಲಿದೆ ಅನಕ್ಷ you won't even hear him, is it? ಓದಿ ಏನ್ ಹೇಳ್ತು ಓದಿ. Yes, please read. What is the reply given to these notices? What reply are given to these notices? No, but held. No, you should have given some reply to the notices. Request of the council for petition list on ಯಾವ ಹೇಳ್ತೀರಿ? Yeah. Yes. Yes. What really extend ಆಗುತ್ತೆ? You need not mention. Number 42 and a dismiss for default ಆಗಿದೆ ನೋಡಿ. Recall ಮಾಡಿ. 2 days. ಇಲ್ಲ ಕತೆ ಬರ್ಬೇಕು ಕೇಸ್ ಆಗಬೇಕು ರಘುನಾಥ ನೆಹರು MN 45 day after tomorrow.
Serial number 56, your lordships.
52 day after tomorrow.
Serial number 56, your lordships.
Huh?
56, your lordships.
2020 other matter. Date put. 29. Please wait 57. All other matters. Madam, we are giving the please adjust. All information please don't make a mistake. Have you mentioned this in the additional written statement? Whatever you are mentioning in the additional statement or the amended, I don't think it is contained in the additional written statement. Please. Anything beyond, I will not permit. Put it. Have you seen this affidavit? Please give a copy to him. Learn counsel for the learn. The party in person, respondent number one, that the affidavit already filed before the court may be replaced by another affidavit that is prepared. To stop. A copy of the said affidavit is furnished to the court. The learned counsel for the petitioner submits that a copy is not furnished to him. Hence, the party in person respondent number one is directed to furnish a copy of the affidavit. There is a amended written statement. Page number 97. Page number? No, how to educate you? How do I educate you? Sir, please understand. You need not put all your arguments into the evidence affidavit. You might reserve your case for arguments at the stage of arguments. Don't put all your arguments into the written affidavit. That is not your evidence, it is your argument. Pleading is like a skeleton. Evidence is like blood. Argument is how you present it. That is all. You can't put everything into the affidavit evidence. Please put a pure questions of fact. That's it. No. Please, if you want to point me, if you want me to point out, I'll point out what are the arguments that you place into the affidavit. You scrub it further. You scrub it further and reduce the affidavit. I can't allow this affidavit. If it is argument, if you are trying to introduce your argument into the affidavit evidence, I will not permit. It should be sheer evidence. That's it. Evidence is questions of fact and questions of fact alone, nothing else. Not necessary. You are producing the document, isn't it? You are marking the document. So you need not tell what is contained in the document. Document itself, you need not say what is contained in the document. That he will cross-examine. You don't give your document has to be seen, it speaks for itself. You need not speak for the document. So anything nature of an argument, I will not permit. Fine. Explaining what the document is, how it came into being, what are the circumstances? No. The document will be looked into as it is, and it will speak for itself. No. Please look into it. If there is any argument that you want to introduce, remove. Reserve all your argument at the stage of addressing arguments. And you should be as crisp as possible. I will do that. Correct. Whatever that you, for example, you can't put into your affidavit what had transpired in the court today. Done, the advocates did that, the advocates did this, they harassed me. These are all unnecessary. This will take away the, what you call the focus of the case. And even if you look at a bundle of papers, if I see an affidavit which runs into 25 pages, do you think I'll be interested to read? It will lose focus. If you want the judge to focus on your case, please you focus on your case first. Reduce all these arguments, unnecessary, what you call extrapolation. Reduce all those things. Please put bare facts in your affidavit. List on date. Take your time, conclude the affidavit properly. 29. I'm traveling abroad from 24 to you must be having your tickets, isn't it? By now. 27th, I'm traveling on. I've got a ticket, I can produce that. Please produce it. List on 24. 24th is Saturday. Then 22nd. 22nd. Please produce your tickets on the next day. I do that. Okay, I will implement the election. Dictation knowledge of please have a speak to the court officer. If he can accommodate you, please take a date.
Court officer. Court officer. Court Officer 52, serial number 52. Serial number 52, list 152. ಕೇಳಿಸ್ತಾ ಇಲ್ಲ ಸರ್, ಸಾರಿ. ಡೇಟ್ ಹೋಗಿದ್ಯಾ?
29 September.
Okay.
Serial number 61. 61. Serial 61. Sir, court officer 61, sir.
Sir, 29 September.
Thank you.
Serial number 56. What is that?
29 September.
Sir, 29 ಬೇಡ ಸರ್, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಡೇಟ್ ಕೊಡಿ ಸರ್.
Sir, 61-29 ಅಲ್ಲ? 61-29.
61.
29. ಆಮೇಲೆ ಇನ್ನೊಂದು ಯಾವ್ದೋ ಇವತ್ತು ಕೇಳ್ತಾರೆ 56.
56 ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಕೊಡಿ.
56 ಅಷ್ಟೇ ಸರ್. 29.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಕೊಡಿ ಸರ್.
ಸಾಹೇಬ್ರು ಕೊಟ್ಟರೆ ನಾನು ಕೊಟ್ಟಿಲ್ಲ.
29 ಸ್ವಲ್ಪ ಪರ್ಸನಲ್ ಇದ್ದಾರೆ ಸರ್, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಡೇಟ್ ಕೊಡಿ ಸರ್.
ಸಾಹೇಬ್ರು ಡೇಟ್ ಕೊಟ್ಟಿರೋದು.
ಅಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಡೇಟ್ ಹಾಕಿ ಸರ್.
ಇಲ್ಲ ಸಾಹೇಬ್ರು ಡೇಟ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಆಲ್ರೆಡಿ. ಹರಿ ಅವತ್ತು ರೀಚ್ ಆಗಲ್ಲ ಬಿಡಪ್ಪ. 29
ಅಲ್ಲ ಸರ್, ಅಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಾಳೆಗೆ ಇದೆ.
29 ಸೆಪ್ಟೆಂಬರ್ ಸರ್, ಸಾಹೇಬ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಾಳೆ ನಮ್ಮ ಕ್ಲಾಸ್ ಮುಗ್ದಾದ್ರೆ ಜಡ್ಜ್ಮೆಂಟ್ ಗೆ ಹೊರಟಾಗತ್ತೆ ಸರ್. ಆಮೇಲೆ ಅಷ್ಟೊತ್ತಿಗೆ ಅದಕ್ಕೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಹಾಕೊಂಡು ನಾನು ಆರ್ಗ್ಯುಮೆಂಟ್ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡು ಡೇಟ್ ಹಾಕ್ಸ್ಕೊತೀನಿ. ದಯವಿಟ್ಟು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಡೇಟ್ ಕೊಡಿ
ಸರ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆಗಲ್ಲ, ಶಾರ್ಟ್ ಡೇಟ್ ಅಂದ್ರೆ 27
ಸರ್. ಸರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಳ್ಳಿ ಸರ್, ಯಾಕಂದ್ರೆ ನಾಳೆಗೆ ಅದು ಕ್ರಾಸ್ ಎರಡನೇ ಡೇಟ್ ಹೋಗಿದೆ ಸರ್. ಅದು
ಸರ್ ಯಾವ ಡೇಟ್ ಹೇಳಿ ಸರ್?
22nd ಹಾಕೊಳ್ಳಿ ಸರ್.
56 56 ಸೀರಿಯಲ್.
Sir, 52 September 29, sir. Serial number 52, did you say September 29th? Sir? Okay.
ಒಂದು ನಿಮಿಷ ಮೇಡಮ್, ಒಂದು ನಿಮಿಷ. ಸರ್
ಸೀರಿಯಲ್ ನಂಬರ್ 56 22nd ಹಾಕೊಳ್ಳಿ ಸರ್.
56 22nd. ನೆಕ್ಸ್ಟ್ 52
sir.
52 27th ಮೇಡಮ್.
Okay, fine. Thank you, sir.